Hello, court officer. Hello, court officer. Madam, court officer. నేను ఆడిబుల్ లేను. హలో కోర్ట్ ఆఫీసర్. హలో కోర్ట్ ఆఫీసర్. మేడం కోర్ట్ ఆఫీసర్. ఎవరు నా పక్కే చూస్తా వాళ్ళ మాట్లాడు, నా పక్క చూస్తానే వాళ్ళ. హలో కోర్ట్ ఆఫీసర్. హలో హలో కోర్ట్ ఆఫీసర్. Hello, court officer. Madam. Hello, court officer. ವಿಜಯ್ ಕುಮಾರ್ ಆಡಿಬಲ್ ಇದ್ದೀನ ನಾನು?
ತುಂಬಾ ಚೆನ್ನಾಗಿ ಕೇಳಿಸ್ತಾ ಇದೆ.
ಬಟ್ ಇವ್ರೇನು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಆನೆ ಮಾಡಿಲ್ಲ ಅನ್ಸುತ್ತೆ ಕೋರ್ಟ್ಗೂ.
ಅವ್ರು ಬರೋದೇ 11 ಗಂಟೆಗೋ 11:15ಗೋ.
3ನೇ ಲಿಸ್ಟ್ ಏನ್ ಮಾಡ್ತಾರೆ?
ಅದು ಇದು ಲೋಕ ಅದಾಲತ್.
ಇಲ್ಲ, ಅಲ್ಲಿ ಹೆಡ್ಡಿಂಗ್ ಅಲ್ಲಿ ಇಲ್ಲ. ನಿನ್ನೇನೋ ಸೇಮ್ ಬಂದಿತ್ತು, ಇವತ್ತು ಅದೇ ಕಂಟಿನ್ಯೂ ಆಗಿದೆ, ರಿಪೀಟ್
ಅಲ್ಲ
ಆಗಿದೆ.
ಅದು ಇದಾಗುತ್ತೆ ಏನಂದ್ರೆ ಅಲ್ಲೇ ಡಿಸೈಡ್ ಮಾಡ್ತಾರೆ.
ಅಯ್ಯಮ್ಮನಾ?
ಅಲ್ಲೇ ಕೋರ್ಟ್ ಅದಾಲತ್ತು ಅಲ್ಲೇ ಡಿಸ್ಕಷನ್ ಅಲ್ಲೇ.
ಎಷ್ಟೊತ್ತಾಗುತ್ತೋ ಏನೋ ಅಲ್ಲ ರೀಚ್ ಆಗೋದು?
ಆಗತ್ತೆ
ಮಧ್ಯಾಹ್ನದ ಮೇಲೆ.
ಇದ್ದಲ್ಲಿ ಏನು? ಶಾಲಿನಿ ರಜನೀಶ್
ఆయన వచ్చి 11 గంటలకంట. ఏమో
ಮಿಸ್ ಆಯ್ತದ ಹುಷಾರು. The notice is served. Notice is served. Mr. Master Monday. Tomorrow.
Appeal by corporation. Appeal by corporation. Execution petition has been filed by threat of attachment tomorrow, my lord.
ನಮಗೆ ಬರಲ್ಲ ವೈಯಕ್ತಿಕ ಕೊಡಿ ಅಷ್ಟೇ. When is order passed?
Passed on 15th of October 2024. It's not fresh matter, it's pending matter. That we heard a few times. The family court had directed the father to pay educational expenses. What is the request here?
Who has filed this with petition?
So the mother's file. There was an order passed refusing to allow the father to file this affidavit of disposal of assets and liabilities. I have questioned the same. I have also sought for an interpreter
Next week, Wednesday. Yes, authorized. Page-wise adjournments.
Kind submission, my lord. For appellants, my lord, the execution 40 of 2025 has been filed by the respondents, my lord, and it was disposed of in December, my lord. The MAC was disposed on. After that, they filed an execution and after the order, my lord. So kindly post it for tomorrow for I stay, my lord. Kindly.
When is the order passed for the tribunal?
Last December, my lord. December 12th.
What are you doing now?
After the execution of we are the cooperation, my lord. We have some of the procedures to initiate the proceedings, my lord. So kindly, my lord.
You take 1 year for the month.
No, my lord. Kindly tomorrow, my lord.
Who is the counsel?
DVK, my lord.
This is what next week. Yes, authorized. Page-wise adjournments, list
So,
number 1, page number 2, 3 to 7, page number 3, 8 to 11, page 4, 12 to 19, page 5, 20 to 23, 20. You inform the other side.
Other side is informed.
Go for the petitioner. Then go for the petitioner, since then we submitted, we already informed the other side, it's a matter of pending. Serial number 15. Oh. This is matter at the request of the council petitioner on 23rd of July. Page 6, 24 to 29. List number 2, page 1, 1 to 3, page 2, 4 and 5, page 3, 6 to 9. These matters don't have to go.
Seal number 98. Seal number 98 in the fourth list, my lord.
One
I pray.
submission, my lord.
Seal number 98 in the fourth list, my lord. I pray for. I am for the appellant. I pray for time, my lord. So 23.
Companies are coming today. Let's see. We dispose it down. That's the reason why all these matters are listed. Wherever all these MFAs, the insurance companies are coming, the officers are coming. We look at it and we dispose it off. That's how it is listed.
One submission, my lord. One submission, my lord.
Yes.
List number 2, serial number 30, my lord. Appellant advocate is for personal inconvenience. She has not come to the court, my lord.
We'll see and we'll adjourn it. Yes. All the rest. Page 1, serial number 1, Arvind Reddy. List 1.
Petitioner in this matter, Swami. This matter is settling actually coming 12th, both. We are made it in payment also. We are made it in payment also. It's in 8th month. So it's coming it in 12th.
Settlement will happen between both the sides, not on your side. He says that the reverse focus settlement.
Praise per time for 14 or 15 you can give me. So
Then I vacate the order and withdraw the time.
give me in praise per timing, my lord. It's in for that in set 12th.
Comply with the order of the court when you
12th only it's coming. It's in we are settled.
there is a. I don't find any order. Please time. This matter after 1 week, yes.
My lord, it's coming it in 12th only. So need it in praise actually for 2-3 days timing only.
On 2/7/2024, this court had granted stay. Subject to petition depositing a sum of rupees 40,000. Within 2 weeks, and at the sum of rupees 30,000.
We are made it in payment. It's in 8 month only.
Within 2 weeks. Thereafter, continue to pay interim maintenance to the interim maintenance in the next week of hearing. It is clarified that in case of violation of the above condition, interim order stands automatically decided. When counsel appearing to the respondent submits that the order passed by this court is not complied with. The stay granted by this court dated 2/7/2024 is vacated and the respondents are at liberty to proceed with the execution. This is matter after 4 weeks.
Serial number 2.
This matter came up on 26/2025. On that day, when counsel appearing to the respondent submitted that the petition has not deposited the maintenance amount delayed. And on that day, there was no representation on the petitioner's side. As the matter was active instead of 3/7/2025. On 3/7/2025 also, there is no representation on behalf of the petitioner. The counsel, the respondent is present. Since the matter was active instead of the capital petition. Here also there is no representation. Accordingly, RPFC is not prosecuted.
Serial number 3. Sridhar Narayan Hegde.
Lord, will withdraw the matter.
ಕೊಟ್ಟಿಲ್ಲ ಅದರಲ್ಲಿದೆ
ಇದೆ
ಇದೆ
Is submitted and the more facility that the parties are visibly settled the estate and hence they are not interested to pursue the matter according to the most taken up record dismissed as withdrawn. Next
4. Shivramu HC.
Appellant. So far as maintainability of the petition is concerned,
order.
it is an interim order. It is an interim order passed by the trial court on section 144 subsection 2. There is an office subsection with regard to the maintainability of the suit, whereas Your Honor has held section 19 of the Act at para number 16. Lordship
Is there
clearly,
interlocutory order?
yes, it is an interlocutory
The
order.
order this is filed.
Yes,
The officer says objection to that maintainability. The petition is at liberty to convert the same within a week. Office objection with regard to maintainability.
Serial number 5.
My lords, I appear for the petitioner, my lords. The petition has now become infructuous because we were seeking interim maintenance. However, the trial court just on 2nd of August July has decided the application. At this point of time, we only seek for a withdrawal of the writ petition with directions to dispose this petition at the earliest. Only directions for day-to-day. The matter may be disposed in an outer time limit of 3 months, 6 months.
In the last petition, the matter came up, there is no representation. Today also there is no representation. For discussion tomorrow.
6.
Obliged, my lords.
Petitioner. This matter, my lord, is office objection, my lord, is along with application trial court. The respondent filed the section 125 clause 2 without affidavit.
This is matter to pass.
My lord,
Office objections are over.
please.
Yes, yes.
Number 7. Madam, in this case, I could not find the affidavit because I could not get the uploaded copy, madam. Order was not uploaded.
But senior advocates online, they were supposed to file an affidavit.
Yes, madam, order was not uploaded, madam. I could not file it. I'll take the, and then file it, madam. Lakshita, give me one week time, madam, to file the affidavit.
Madam, you are not audible, ma'am.
Audible. Am I here? You're actually able to hear me, madam?
I think it's muted from your side. Audio.
Am I audible, madam? Am I audible, madam?
Yes, you're audible now.
Yeah, madam, I could not find the affidavit because the order was not uploaded. I could not get a copy. I will do it, madam, and within a week I will do it, madam.
Uploaded on the same day.
I will do the.
Already, sir. Sir, upload agide.
Order is uploaded on the same day.
Madam, I could not, madam. I'm sorry, madam. I will see. My colleagues told it was not uploaded.
It's uploaded.
Sorry, madam. I'll take the copy and then do it, madam. I'll take the copy and I'll do it, madam.
This is the second time advocates are making complaint that it is not uploaded. Long back it is time.
ಆಗಿಲ್ವಾ ಇದು
When can you file?
14,355.
Yes, sir.
This is matter next week. And please upload and inform.
Yes.
Next date. This is a matter on
15th, sorry, 15th.
15th.
Yes, sir. Yes, sir.
Serial number 8, Virupakshaya PH.
My lord, memo for the withdrawal.
Take the memo. The memo is filed straight in that. MC number 295/2021. Is disposed of by order dated 2/5/2025. As such, there is nothing survives for consideration in this petition. And the petitioner wants to withdraw the petition. The memo is taken off and dismissed. Next.
Serial number 9.
My lord.
Appearing for petition, my lordship. IA may be allowed, my lord. Continuation of delay.
Have you filed your objections to this idea? Let's see of 2024. When did you enter FL? Last year. So filing objections to the idea, finally, a week's time.
Delay may be condoned, my lord. Delay may be condoned.
You want to file objections to the idea, you want the delay to be condoned, how?
My lord, the visitation regs has been violated, my lordship.
This the matter on 17th.
Cell number,
Further adjournment will be granted.
cell number 10, Puneet C.
Notice.
Please, my lord, may I request
Sir,
for a
number
date? I'll take hand summons also.
The petition is permitted to take for answer to the council FIA for the respondent. So there is nothing pending before the court. Whom you will take?
My lord, to the respondent himself. Why? Because
Notice to the respondent, emergent notice.
Cell number
I
11,
request for date at least.
Once the notice is served, this is the matter.
Please.
cell number 11,
Lord, I appear for petitioner
Trivikram.
in the first matter.
Appear for respondent, my lords.
Counsel for respondent has served a copy memo along with some documents, my lord. I will go through it and make my necessary submission. maybe a week's time may be granted.
My lords, I am filing it.
Don't file anything here, file it before the section. Without whenever the court is taken, you are not putting any number. It is becoming registered for the court. Then counsel is writing for the petitioner in WP 1025 actually.
Please, my lord.
Submits that the counsel has served certain documents and he needs to file his objections to that. This is matter on 29th of July.
Much obliged.
Cell number 12.
For the petitioner, please.
Yes.
124. The order dated 21/11/24 was under challenge before the Honorable Court. Husband's petition, my lords. The trial court has ordered an amount of rupees 30,000 per month.
There is again today.
Lords,
There is again today for the state.
lords, earlier it was filed RPFC. It was got converted.
You said that, remember on the last occasion.
It was wrongly mentioned that, my lords. Interim prayer only I am pressing for that. I don't know why it was listed for that. Lordship has directed me to file the amended petition also. Last occasion, amended petition was accepted and posted this today for admission, my lords. It should have been admission.
You're not seeking any interim order.
Interim order I am seeking, my lord. In writ petition, I amended.
This cause there is no idea. But stay.
No, this is a writ petition, my lord. In interim order, I am asking for writ petition FC.
For that there won't be any idea.
No, it will not be, my lords. It will not be.
Don't have to file an idea for this.
There will be ground for interim prayer and the interim prayer will also be sought, my lords.
What is the interim order?
Lord, annexure E, my lords. First petitioner is the wife, other petitioners are the children, my lord. Page number, my lord, 59. They are married for about almost 14 years, my lords. The dispute arose only after 21/10/2022. Children, 10,000 for a wife. First petitioner is 10,000, my lords.
4 children.
4 children.
20,000.
Yes, my lord.
And to the wife,
10,000.
what is the income?
45,000 rent. I bought 2 properties in her name, my lords. One is apartment, another one is a site. So she let it out to other parties. The dispute arose, my lords, only after 21/10/22. I allege that there is my income. I am working in Dubai. My income is in Indian rupees 1,90,000. As per their say, it is 90,000. I have a liability of 1,18,000 towards the loan to purchase of. Yes, my lords. Ink page number 59. Trial court has rightly observed that I am paying entire education. 9 minutes. The respondent in his affidavit of assets and liability referred to the education expenses of 3 school-going children and also declared his salary at 2,900 per month in Indian currency. The respondent claims that he is having loan and he has to pay 95,600 per month. The respondent in his affidavit of assets and liabilities referred about his liabilities and EMI to be paid towards the loan account. Admittedly, petitioner is a housewife. The respondent claims he purchased property in the name of petitioner, but the petitioner without knowledge or consent let it out property as she is receiving a rent of rupees 45,000 per month. The respondent further contended that even today he is ready to take back the petitioner with children. The petitioner residing separately on her own will and wish on 22. The record placed before the court shows that both the petitioner and respondents are residing separately since 2022. Since the petitioner is a housewife, in order to meet the expenses, she might have let out the property and no fault can be found in the act of the petitioner number 1. Though the respondent claims that he is spending 3 lakhs towards the education expenses of the children, the record shows that through the orders on 14/7/2023, respondent was directed to make payment towards the school fee and children for the academic year 2024 and the report complaint. Thereafter, the matter was posted on KMC for mediation and the mediation report received matter not settled. Then the respondent filed his statement of objection and also filed his affidavit of assets and liability. On 14/12/23, the petitioner reported that he has not paid the school fee of 3 children. Considering the circumstances of the case on hand, through the orders dated 14/12/23, the respondent was directed and make payment towards the school fee of children without fail and report complaints. Thereafter, the respondent filed memo dated 27/12/23 with copies of the documents reporting payment of entire school fee of all 3 children till date. Since the petitioner is housewife and all the 4 children are under care and custody, the respondent is bound to maintain the petition and all the 4 children in par with the standard of his living. And he is also bound to meet the entire education expenses of the child. Admittedly, respondent is employed in Abu Dhabi and he is earning. Hence, he is. This matter, my only endeavor is for the past 5 years, he has not allowed me to visit my child. I filed separate application for this kindly appreciate as per 125(4), if a spouse without any reason is a here I am ready to pay my children expenses. I am ready to pay 10,000, 45,000 rental from one house, and other side she has lent it for the parking quota alone 40,000. It is unaccountable. But 45,000 in the apartment of 3 bedroom she is getting. I am paying 10,000 and avoid my wife. Children they also. Your lordship may avoid the 10,000 of wife, and they have filed already execution. But I am ready to make payment towards my children. Yes, madam. Children, not necessarily, madam. I kindly appreciate all the 4. Yes.
No problem for you to pay for the children. Then we'll do one thing, pay 20,000 to the children. As far as 10,000 is concerned, that I'll stay.
Yes, madam. 10,000 of wife, please kindly stay that. Children, I am ready.
The wife is getting 45,000 rent towards the rent of 45,000 rent from the property purchased by it. And in spite of the court has granted the labor, it is submitted without a reasonable cost. The wife is staying away from the husband. It is submitted that as far as the children are concerned, is ready to pay. The wife is concerned, she will not require for considering the submission. And also, the perusal of the order shows that the court has also given a finding that the wife has not stated how much the amount she is receiving has rent from the said property. Considering the same, there is a stay of all. There should be stay of all further proceedings as far as the maintenance that is granted to the wife, and as far as the children are concerned, the petitioner shall continue to pay 20,000 the 5th of every succeeding month, and the arrears, if any, at 20,000 shall be paid within a period of 8 weeks from the date of receipt of the property. In the hands of the respondent, you shall file a memo to the effect within 2 weeks, within 3 weeks. If the memo is filed, this is the matter. If the memo is not filed, stay granted by the court as
Cell number 13, G.R. Mohan.
Respondent, my lord.
G.R. Mohan, M.N. Raghu.
Appear for the petitioner. It's an order passed by the London Family Court, Annexure A, your lordship. The suit has been filed by the respondent plaintiff against the wife, who is the defendant, saying that I have put up construction on the property and I paid towards the cost of the construction 1 crore and odd. Accordingly, the application was filed under R38 Rule 5 without even going into the merits of the case and other things, because the property belongs to the wife, the petitioner herein, and also she got that property under gift deed, and her parents have contributed towards the construction. So, and he has also filed another suit, your lordship, before the city civil court. And here now, yes.
What is the suit for?
The suit for recovery of money, your lordship, this present.
Filed by whom?
By the defendant, that is plaintiff respondent. Plaintiff. This is the petitioner is the defendant, your lordship.
Filed for husband.
Yes.
My lord, husband has filed a case against his wife for a recovery of money for the construction the amount which was invested on the building. That is the suit.
Where is that affidavit in support of that case?
Yes, my lord. Kindly turn Annexure B. Annexure B is the plaint. Annexure C. If he, sir, ನಾವು ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೋದಾ? ನಾವು ಸಬ್ಮಿಷನ್ ಹೇಳ್ಬೋದಾ? ಹೇಳ್ಬೋದಾ? ಅಲ್ಲ ನೀವು ಹೇಳ್ತೀರ ಅಂದ್ರೆ
ತೊಂದರೆ ಇಲ್ಲ.
My lord, kindly see the annexure C. Is the application Order 38 Rule 5. We have detailedly, kindly turn page number.
Plain copy there. 290. 290. 290. 42, total 42. Continue. ಇದಲ್ಲ 290. ಇದೆಲ್ಲೊಂದು ಚೆಕ್ ಇದೆ ಗೊತ್ತಾ? ಇದೆಲ್ಲ ಕಂಟೆಂಟ್ ಅವ್ರು ಹಾಕಿರೋದಿಲ್ಲ ಇದು ಬಿಡಿ.
What are the documents that are placed before the court to show that you have spent money?
Now I am producing the bank statement which the respondent.
Documents are filed before the court.
Yes, sir. Yes. We have produced in trial court. I'm also show the copy to the petitioner counsel. I made a booklet. the respondent has mobilized the amount which are mentioned in highlighted. Kindly turn the page number 4, my lord. 4. Page number 4. Your Honor, my lord, it is started on 7/11/2021 for a bore drilling from the beginning, which is started from the bore drilling. He has paid. This is page 5 is nothing, and page 6 also turn page 6, which are all marked or invested the amount to construction the house. Here, the petitioner has no document to prove their investment. She making a small allegation that her parents have invested. Here, my lord, the petitioner mother is working a D group, now is promoted as a SDA, and his father retired military employee. He got. Yes, yes, it is all my investment. Totally 1,35 lakhs, my lord. Yes, yes. And I have declared in my income tax, I have produced the document number annexure R3, my lord. Kindly turn my objections. I have declared in income tax. Yes, sir, I have produced.
No, in the statement of objection, yes.
Statement of objection, I am along with statement of objection, I filed the document. Annexure R3. And annexure R5 also stated.
No, in the annexure R3, he has not mentioned anything about the
Please, I will complete then.
payment towards the cost of construction.
Annexure R4, R5, my lord. Kindly turn annexure R5, page number
R3.
25. 25. Page number 25. My lord, kindly see the assets, fixed assets. In the column 1, 3, 4, 4th one, site number 28. Building construction, first B main road, 4th C cross, Srigandha Kaval, Egnalli cross. It's the amount 1 crore 40 lakhs 5,500 rupees, which is invested by the respondent to construct the house. In the last year, my lord, 31/3/2023. Dispute started on 17/11/2023.
Lordship, the claim is that he has put up cost towards construction of 1 crore and odd 45. He has claimed that in the plaint. These documents, your Lordship may kindly see, in the returns filed before the income tax as per Annexure 3, nowhere it says that he has paid the such amount towards the cost of construction. Anywhere in this returns he has filed. Now, all these documents, they are all pertain to his company, where a logistic company is doing. In that, if your Lordship look into the no, the only thing is that my responsibility, let the trial go on, let him prove. Then by virtue, if we succeed, I definitely have to want to. Now question is, he has also filed a suit in OS number 290 before quota number 42, CH-42, wherein he has filed a suit for injunction not to alienate. Then that was rejected. Then they came up in appeal. Appeal is also dismissed. Now, indirectly.
No, partly allowed, sir.
Just this suit is filed subsequently. The earlier the suit was filed in. Yes. No, nothing prevented him from filing a comprehensive suit there, because he has already filed a suit where in the subject matter of the property only, scheduled property is mentioned in that OS 290, your Lordship. That is at.
My lord.
No, only thing is that.
Suit for injunction.
Injunction not to dispossess him.
Not to dispossess and not to alienate the property. Then trial court, 1 minute. Trial court was dismissed both applications. Then I approached the dishonorable court. Dishonorable court dismissed the for not to alienate and consider the not to dispossess partly allowed, and status quo has been granted. No. It is against the petitioner and her parents, and this case filed before the family court only against the wife. There is no other members there. No, my lord, initially they are trying to alienate the property. We filed a suit for injunction. Yes, I produce it, my lord. Kindly turn annexure R. Yes. Annexure R10. Illa, nanu objection. Page number 58, annexure R10. In 65, madam, page number 65, kindly turn page 65. This honorable court has mentioned, yes, he mentioned, then he is at liberty to seek a said remedy by prosecuting independent suit in OS 275. That is what in page number 65.
No, in
In
fact,
objection.
paragraph 6, Your Lordship, page 64, there is already objection by the trial court, page 64, Your Lordship. Paragraph 6, in the record by the, in the
Page-
MF, Your Lordship. Details have been discussed.
Yes.
OS number 275 is the present.
This one. Now kindly see the, at the,
OS 275 is the present.
It is under challenge.
Present suit.
Ah, yes.
and in fact, the observation also that by the, in the other proceedings, that he can't claim his ownership or whatever it is there. Merely, that has to be proved by trial. Only submission is that let him prove. If I am liable, I will pay. Question of
kindly turn
attachment doesn't arise because not to let order was rejected earlier and affirmed by this normal court in MFA number.
My lord, kindly turn annexure R11. After rejecting the application in the civil court, the petitioner has published in paper, Prajavani Kannada paper, stating that is for selling the property. I have produced a copy in annexure R11. He has given a paper publication. What is our intention beyond this? Now she trying to defraud the plaintiff, my lord. After rejecting the application in the trial court, in injunction suit, she has published in paper in Prajavani Kannada daily newspaper, stating that for sale, his property is mentioned, a phone number also mentioned. Page number 74, my lord, annexure R11. Annexure R11. Sir, madam, kodi. Xerox.
The husband had filed OS number 275 seeking recovery of money. It is a case with the husband that he had spent huge amounts towards the construction of the house. And the later differences between the parties. The wife has the house is constructed belongs to the wife, which was gifted to her by her parents. She did not agree the husband to enter into the house. Initially, the husband has filed OS number
290/24.
90/24.
that is filed.
Injunction.
In that he has filed 2 IAs. One is not to dispossess and not to alienate. When the 2 applications were discussed, the same were carried to this court. And this court in MFA number
Yeah, two MFA numbers, my lord. MFA 7683, 7693.
7693 of 2024, dated 9th December 2024, has allowed MFA number 7683 of 2024 in part.
Paragraph 9, last paragraph, Your Lordship. Paragraph 9, last line.
And not to cause any obstruction to live in the respective court till the disposal of the bill. Now, when there is an order of status quo, how can it be disposed?
My lord, she trying to alienate the property.
And in that case, you should file a contempt.
No, yes, we have filed another.
Only status quo orders. Please.
Why should there be another order? Not to, no, there is an order of status quo with respect to that.
That application dismissed. Yes. Therefore, I filed a recovery proceedings in the in the trial court, in the family. Yes.
Already you have an order with regard to that property. It is an order of status quo in all respects. Is it?
Prior to status quo order, we have already filed a suit
No.
for recovery of money. My lord,
So when is this order of status quo in MFA? In MFA, MFA order is stated.
MFA only status quo for not to dispose the plaintiff, not for alienator. That is what I.
That not to alienate, the prayer was rejected.
That prayer was rejected.
Rejected. That is fine.
Thereafter, when the suit is filed,
When the suit filed on. What is it?
The present suit was filed on 1st July 2024.
1/7/2024.
Whereas the earlier suit was filed on
2024.
so the application is filed.
earlier suit was filed on 8th January 2024. 290 of
Attachment for judgment of the application schedule property. By which the order issued, the court had directed the defendant, the wife from transferring or changing the application schedule property in any way. And the court has prohibited from transferring or charging the application schedule property in any way, and all persons from taking any benefit from the transfer or charge. The court, while passing the order, observed that the husband, in support of this case, has furnished the invoice to purchasing the iron, cement, and other building materials. He has also furnished the bank statement revealing about the payment of amount. And after finding of the idea from the plaintiff, the court had directed the defendant either to furnish the security of the show cause why she could not furnish the security. But the defendant did not comply with the order of the court. Further, the court has also observed that the defendant has contended that the parents gifted the application schedule property to her. There, with the assistance of the parents, she has constructed the building. And the defendant in the written statement have not revealed that she is having her own income. The court has also observed the defendants have already issued the application intimating about the elevation of the application schedule property. Considering all this, the court had granted the relief, restraining the defendant from alienating the property. Next, when counsel appearing with the petitioner, defendant, petitioner, wife, public defendant submits that the court, without appreciating any of the facts, and particularly the fact that in the earlier suit, the idea that is filed seeking not to alienate was dismissed, and the fact that the husband has failed to establish the fact that he has spent any amounts towards the construction of the house has granted the relief, and the court ought not to have granted such an and the relief that is granted is complete to the provisions of Order 3825. Submitted that the order review needs to be set aside. Let counsel appearing to the respondent husband, public, the plaintiff submits that he has placed before the court the bank statements, the income tax returns for the year 2023 to show that he has spent substantial amounts for the construction of the house, whereas no other material is raised by the defendant in support of their case. It is submitted that in the earlier suit, when the court had dismissed the relief not to alienate, however, the trial court has made an observation that the plaintiff can seek the reliefs in the suit that is pending for recovery of money. submitted that there is an order of status quo in the MFA. And the company filed with them is partly allowed. However, that the status quo is with regard to the position. He submits that the plaintiff could prove that he has spent substantial amount and the action on behalf of the defendant by giving the state of obligation. They have shown the intention to that they are going to alienate the property. If the property is alienated, that means that it's not in the petition, even if the suit is decreed, will not be in a position to realize the fruits of the decree. The court had rightly considered all these issues, rightly granted the deed. There are no grounds to take a. I'm going to do the section on it. In view of the strained relations between the parties, the husband had filed a suit for recovery for the injunction, restraining the wife from interfering with this position. They also filed for 2 IAs. One is from termination, and the other is not disposal. As far as the not disposal is concerned, the appellate, the court, the MFA had granted an order of status quo. As far as not to alienate is concerned, the same is dismissed. Now coming to the present suit, it is the suit for the of money. It's a case of the plaintiff that he has spent substantial amounts for the construction of the house, and technically the property stands in the name of the wife. The document that is filed before the court, that is the bank statement and the income tax returns, are placed before this court to show that he has spent substantial amounts. It is a case of the defendant that it is not in dispute that the wife is not having any income. And according to the said construction is made by her parents, with the parents' support, the said construction is made. The court had rightly considered all the documents that are placed before the court, and particularly the payment obligation, showing that they're going to send the full schedule from they're going to send the property, which is in question, which according to the plaintiff has spent substantial amounts. Unless if this property is disposed, the property is alienated, even in case the petitioner succeeds, the plaintiff succeeds, it is difficult for me to request a set amount, which is the part code of 3825. And in the considered period of this court, the court had rightly considered and passed the order. There are no reasons to interfere.
14, Akarsha Rao for petitioner, Aminulla.
Here for the petitioner this case. Lordships may kindly recall, Lordships have directed me to file a memo of calculation. It's ready, if I may be permitted to file.
Give a copy to him.
I'll give it.
Just look at it. The council has when do you want?
Next week.
It's a matter of please.
Great.
Cell number 15, adjourned 16. Gitanjali.
The petition is a husband who's before this honorable court. Being aggrieved by an order, ex parte order passed by the magistrate, my lords, I'm here. But petitioner is a husband who's 100% disability, my lords. He's blind. He cannot see. Your lordships may kindly produce page number 20, where I produce a disability certificate, which shows I'm 100% disabled. The wife completely. My lords.
Because never stated with the right that
She was never stated, my lords. In the entire petition, which is in. It was served, and therefore I'm here before the court, my lords. Notice was not ex parte order, my lords. I was not given opportunity. My lord,
he has has not filed objections either to the main petition or to the allegation.
My apologies for it, Minutes. My apologies for it. But this aspect of disability was not said by the wife, Minutes. She is married to me. We were married for 3 years. Minutes, I should have, my lords, but I would not have been able to contact my advocate. That is the impertinence that has been caused.
No, when we can contact the advocate in High Court, why not then?
Minutes, I understand. The matter may be remanded back until then, until.
There's no other work.
Minutes, I do understand. But he is a disabled man, my lords, today.
He can come to the High Court.
I understand,
He can
Minutes.
understand that he has not, notice is not served, he has not engaged.
That's right. Yes.
Wasted court's time to pass this order on 17th May. And then again, now this court will pass the order, again it will go back.
Minutes, your lordships may remit the matter back. Within a week, I will file my objections and contest the matter, Minutes. Because the wife has deliberately suppressed this. And she has produced certain RTC extracts of my mother to claim that I have certain properties.
The counsel appearing to the petitioner submits that the petitioner husband is as per the disability certificate, is 100% blind, 100% disabled visually, and the court, without considering all this, has granted an amount of Rs. 8,000 per month. This court has produced the order. It appears that the petitioner rendered appearance to his counsel on March 20. Not validated objections either to the main petition or to the allegation. It's objection by the respondent is taken into possession and court had granted 8,000. Then counsel submits that we should not reject this counsel. This court is not able to appreciate the said submission made by the counsel as it has become a routine practice that the parties not appear before the court and come before the court. This court is seeking remand of the matter. However, in the peculiar facts and circumstances where the petitioner is blind and has to disability certificate, he has 100% disability. They shall issue a court for the proceeding in so and so. The petitioner shall take out the handsomens from the counsel appearing before the respondent before the trial court and shall file a memo to the effect by 29th of July. If the memo is not filed, the stay granted by this court stands vacated automatically. If the memo is filed, it's the matter immediately.
Cell number 17.
Deeply obliged, Minutes.
Call is connect word, party in person.
My lords, may please be appear as party in person. Form C is issued by the party in person committee, aggrieved by the order passed by 4th Additional Family Court in a GWC matter. I'm before my lords. Impugned order is from 17 to 30, marked as Annexure A.
How are you agreeing with this?
The IA was requested for 2 events. One is for my birthday, and the second event is on the same day, which concludes my father's birthday as well as my parents' anniversary on the same day. So 2 events. I filed IA number 12.
Notice the response, takes handsomens and the counsel appearing before the court and file a memo to the effect. If the memo is filed, it's the matter immediately.
Cell number 18.
Much obliged.
HP.
Appearing for petitioner, my lord. My lord, we have filed for the modification of the maintenance, like which has been like earlier 15,000 was granted, my lordship. Thereafter, like we filed a RPFC and it was reduced. Yes, my lordship. Now she has been remarried, my lordship. She is a doctor. She is having 2 clinics, my lordship. Whereas, like page number 29, my lordship. Relevant question.
A number 3 filed under so and so by the respondent is rejected. According to you, she is married or
She is remarried, my lordship. Like at page,
where is it discussed?
my lordship, photograph at page number 110, my lordship. One month. Annexure Q, my lordship.
What is wrong with this order? I'm not able to understand. According to you, you have to pay 5,000.
Okay, he has been complied. He has been paying 5,000, my lordship, as per the order.
When the order is not modified, you're supposed to pay 50,000. Is it not? Read paragraph number, page number 28.
Whereas I am working in a medical shop, my lordship, she has 2 clinics, my lordship. She's running a good.
When one order has become final, we will not look into that. According it's your case that she is remarried, you are not entitled. You don't have to pay the maintenance. As per the order in the RPFC, what is the amount?
5,000, my lord.
What is the respondents?
Cell number 19. Kumar, you for petitioner.
In this case, I have not challenged any order, only challenged the respondent's conduct of protracting the proceedings. Every stage has been allowed to lapse multiple number of times, then repeated applications were filed seeking recall, and taking into consideration the larger interest of providing an opportunity to the respondent, applications were allowed, and some applications we did not object it also, but issue a time frame to be fixed. Now it's posted for cross examination. 19. 801 of 2019.
To dispose of the case as expeditiously as possible. Extract the plea. The petition is filed seeking the following plea. Then comes with the petition submits the matter of plea for practice right from 2019 till now in the last 60 years. The matter is pending before the principal judge, Family Court Bangalore. The Family Court of Bangalore, Family Court of Bangalore.
Third additional court. That is pending before the third additional court.
The family courts at Bangalore are making their best efforts to dispose of all the matters pertaining to 2019 by December 15th. In that view of the matter, the dispute deems it appropriate to direct the court to dispose of this petition by December 15th, 2025. In notice, not issuing notice to this court. This is just for the parties.
For admission, cell number 20, adjourned 21. Ajay Prabhu M for petitioner.
Well, serial number 20.
My lord, saying 20.
Well, last occasion, your lordship has said to file the statement. No, they have not informed. Even I sent the message. No, he has not informed. Even I called him at 10:30. I want to submit the.
In the morning, the mention is made to the counsel for the petitioner that it is informed to the counsel for the respondent. When counsel for the respondent submits that it is not informed to, this is a matter tomorrow.
Please.
No.
21. Ajay Prabhu
Matter is,
M.
that is what matter has been settled. That 18, that 21. My lord, that it was in husband has filed divorce petition. That matter was referred to mediation.
So where is the report?
My lord, it is my lord, the matter is for settlement on 18th before trial court.
And we want.
So 19th or 20th.
This is matter on 28th that the matter is going to be settled between the parties.
Please.
Cell number 22.
Interim order may kindly mention. Please.
22. Devendra N for petitioner.
May I request my lordship kindly pass over
Internal
cell number
clear.
22. Proxy counsel for petitioner counsel. Obliged.
Cell number 23.
Appearing for the petition in this matter, my lord.
23. Venkatesh.
By the order.
Venkatreddy.
Petitioner is aggrieved by the order, my lord, under CMS 125 of impugned order annexure, operative portion of the order, my lord, annexure A.
What is the amount that is granted?
Amount is paid by 4,000 and 6,000, my lord. 4,000 paid by the first respondent, the 6,000 is second respondent, my lord. In the divorce petition, my lord, permanent alimony is already awarded, my lord.
When was the alimony awarded?
Family court, my lord. Annexure B, my lord, page Page 75. 3 lakhs is, my lord, date of order 30th January 2025, my lord.
30th
January 2025.
2025.
Please, my lord.
How much is awarded?
3 lakhs.
Then
Semis order. This order, this interim order is also very same court is passed by the order, my lord. In addition to that amount, he has paid to monthly maintenance 4,000 rupees, my lord.
30th January.
Same date, my lord.
Earlier is also 30th January.
Earlier is 30th January. Same day order was passed in the two.
And the court records that finding one.
Please, my lord.
Come to the
Page 48, my lord. Page 43. 43. 42, operative portion. Petition filed by the petition under section 125 CRPC.
I'm asking you about the finding with regard to the alimony and this.
In next page, my lord, 43. Third last paragraph. The amount is maintenance awarded in this case is in addition to what the order is CMIS 72 of MMTC. In the DV Act is also awarded 4,000 rupees, my lord. In addition to that awarded 4,000 rupees.
This order, there is a discussion about the permanent alimony.
Permanent alimony in the divorce petition, my lord.
Is it discussed by this court? Is it the same court as granted it?
Please, my lord.
Where is the discussion that I'm asking?
Page 37, my lord. Internal page 28. Page 36 onwards, my lord. Para 27. The petitioner is claimed the monthly maintenance 40,000. Petitioner have produced the document exhibit P3 when the shows that the petition number 1 has spent a substantial amount to the education of the petition number 2 exhibit P3 shows that for the first standard to fifth standard total fee is 42,900. There will be a
So you're paying, you paid 3 lakhs.
already paid, my lord.
And you are paying 4,000 as maintenance in DVC.
Please, my lord.
Wife and
Children, daughter. Daughter, we are
what is your income?
21,000, my lord.
21,000.
21,000.
But somewhere I thought is 1 lakh. Come to the order where is a discussion about your income. Where are your statement of assets and liabilities? The respondent is having monthly income of 1,50,000.
1,50,000. Salary certificate is produced, my lord. 23,000, my lord. Drawn on 21,000, my lord.
So it comes to the petitioner submits the MC that is filed by the husband.
The husband, my lord.
Seeking divorce, completely. In that the court had directed to pay an amount of 3 lakh as permanent alimony. And in the BBC case, husband is already paying an amount of 4,000 as maintenance. In addition to that, no, the court has granted an amount of 6,000 to
Daughter.
the daughter and an amount of rupees
4,000 to wife.
an amount of rupees 4,000 to the wife. And the salary of the husband is 21,000.
21,000.
That's been the submission in the financial capacity of the husband. Patient history of all further proceedings. In so. The petitioner, the other side, the history is directed to emergent notice. The response.
Preliminary hearing B group, cell number 24.
Number 24, appear for the petitioner.
Vijay Nayak.
Your Lordship, there was an interim order granted wherein the petitioner husband could get visitation rights over his child for 3 Saturdays in a month, Your Lordship. What has happened is respondent failed to bring the child on three occasions, Your Lordship. The interim order was passed in February 2025, wherein on the first, second, and fourth Saturday, when there are 4 Sundays, when there are 4 weeks in a month, and when there are 5 Sundays in a month, it will be first. Yes. Order dated 27/2/2025.
Keep the respective parties present is 27/2.
Please.
Where is the order?
Order, it's an interim order, Your Lordship, on 27/2.
28/2 is the order.
I have the interim order, Your Lordship, 27/2.
I also have the order, it is 28/2. 27, there was interaction between the parties.
Yes, there was in chambers proceedings, Your Lordship. Yes, in chambers proceedings, and Your Lordship may kindly see the operative portion of the order.
So what happened after?
Your Lordship, this order came to be modified because second Saturday would be a holiday, Your Lordship, second Saturday and the fourth Saturday. So it was changed on 28.
The second Saturday.
Yeah, it's second Saturday was third Saturday. Yes, yes.
First, third, and fourth Saturday.
They have brought the child, Your Lordship. But on 3 days they have missed the child 3 working days, which is on the 26th, on the 19th of April, 26th of April, and 7th of June. They failed to bring the child, Your Lordship.
27.
Compensate that, Your Lordship.
So now, what is the order passed by the family court?
Visitation was granted only for 1 Saturday in a month, Your
So
Lordship.
what we do is, this whatever arrangement that's made by this court, we'll make it final and let the court decide the matter.
Let them compensate. Again, last time also they took time for this, Your Lordship.
We should have done it by this time.
In
2 weeks back, I have taken the score of this file. I have to take instruction from my client also. Child is going to the school. All of a sudden, they are asking for modification of this.
child is going to school, it's on Saturdays.
I'll pray for 2 weeks.
What modification they are seeking?
They are seeking modification of visitation.
What are the dates? They're seeking on a Saturday. School notes to the daughter work. The girl is 3.5 years. They won't be in school on Saturday.
No. She is 4 years and that. Now
Still,
she is going to the school. I
On
have to
what
take
day?
instruction.
On Saturday she has school.
Saturdays also. I have to take instruction from my friend, then I will file my application. And I bring some more facts.
How you are able to comply with this order when she is having a school on Saturday?
We complain.
How? If she is having school, how are you able to comply with the order?
That we can, prior permission we can take from the school mail. Otherwise, every Saturday we see this.
But next date of hearing, learn counsel for the petitioner before this court. The learn counsel, the respondent shall place it before this court. The court, whether a Saturday, an affidavit shall be filed. Whether the Saturday is a holiday or not for the child. This is the matter on 15th.
Obliged, Your Lordship.
Cell number 25, Manjunath H for petitioner, Nagaraja N.
Waiting for the petitioner, my lord. It's the MC petition, my lord. This is the respondent writ petition challenging the order dated 7/1/2025, MC number 34 of 2023, on the file of family judge Tigbalapur. My lord, the annexure D may kindly be presented to ink page number 62, my lord. Here the application made by the petitioner before the honorable trial court seeking that please to recall the order posting the above matter for petitioner evidence. Impugned order is page number 23, my lord. Orders on IA number 4. May I read, my lord? This is an application filed by the petitioner under section 10 of the Family Court Act, read with section 151 CPC, seeking to file his rejoinder statement in consequence to statement of objections filed by the respondent stating that the respondent has made false allegation against him. MC is filed by the respondent, husband.
Not for the wife.
Yes, ma'am.
So what is this impugned order?
My
Where
lord.
is this ID number 4 application?
That is the page number 61, my lord. Annexure D, page number 61. '62. The prayer made in the application is that to recall the order posting the matter to the petitioner evidence and permit him to file his rejoinder statement to main petition filed by him in sequel the statement of objections filed by the respondent in the above matter to meet the ends of justice in equity. Here we filed the objection before the honorable trial rejoinder to the petition. After filing of the statement of objections to the main petition, the matter posted for petitioner evidence. During that stage, he has come up with the application saying that there is a character assertion is made by the respondent in her statement of objection.
Main petition is filed when?
Dated 31/5/2023.
When were the objections filed?
Objections filed on 6/2/2024. 2024. Without any counterclaim.
When was this application filed?
Filed on 17/12/2024.
What has happened between 6/2/24 and 17/12/24?
The matter mediation. The matter was referred to the mediation and
Then let him do it what's restricted.
my lord, here the case, the objection of the respondent before the trial court is that without the counterclaim, whether the petitioner is entitled to make out a rejoinder. Only option available to the petitioner is to amend the petition. If you want to add any further pleadings, he should make the amendment application.
Procedure. To be introduced here. So the best option available for the husband was to rejoin. It's not amended. To counter the allegations made by the.
So what is the prejudice that will be caused to you now?
My lord, section 10 of the Family Court Act, I will read, my lord. Proceedings generally subject to other provision of this act and the rules, the provision of Code of Civil Procedure and of any other law for the time being in force shall apply to the suits and proceedings other than the proceedings of chapter 9 of the Code of Criminal Procedure before a family court shall be deemed to be a civil court and shall have all the powers of such court. Here my learned friend is saying that section 10(3), subsection 3, nothing in subsection 1 and subsection 2 shall prevent a family court from laying down procedure with view to arrive at settlement in respect of the subject matter of the suit proceeding at the truth of the facts alleged by the one party and denied by the other. Here the case, the CPC is applicable like a civil court and civil court CPC is procedure. We have not made any counterclaim and in the proceedings, it is not for the settlement of the issue the court, family court has arrived for the such conclusion. Interim order may be extended.
Reserved.
Interim order extended.
Reserved.
IO may be extended. Stay may be extended. Applied.
For judgment, cell number 26, Aditya D. For petitioner,
Appearing on behalf of the petitioner, madam.
Alan Govindraj.
what are your instructions? Asking if the court audible to.
Hello, sir.
Yes, my lord.
What are your instructions?
My instructions in the sense, my lord.
My God. Yes, what are your instructions?
My instructions are to contest the quantum that has come up with regard to the maintenance, as well as the order that has been passed with regard to 20,000 rupees as legal fees.
It's not
Considering
about
that,
that. Yesterday, when the matter came up, I asked
yes, my
you
lord.
about the emails. What is happening? Why is he sending that in spite of an order of the court?
Yes. My lord, I've spoken, and I've told unempirically to my client to immediately cease and desist any sort of communications. I had a lengthy conversation with him about for an hour, explaining that this would not be accepted further on. And my client has told me quite specifically that he will cease and desist immediately.
Yes. So I'm confirming this order.
My lord, if I may, my lord, the 20,000 rupees that has been granted as legal fees, taking into consideration there is a parity in terms of payment, that salary between both the parties, the rationale that has been put forth by the court as to why the petitioner should foot 20,000 rupees of the legal fees of the respondent is something that the petitioner would like to, contest.
What do you say on that?
He's already paid it.
He's already paid.
He's paid and said it for
Yes.
legal expenses. He's already paid it.
It's been paid, but we would like to submit that since the court has taken a stance, there is a parity in pay. The fact that that is, the petitioner had to foot that 20,000 rupees as legal fees is something that the petitioner felt unfair.
Agreed with orders passed in I number 2 and MC number 8026 of 2023, dated 5th March 2025. The husband is before this court. The wife, MC is filed by whom?
MC is filed by the
So referred to as wife and husband. But as rightly submitted by him, now she is in a position to prosecute her litigation. Why should there be a legal fees?
He's already complied with the order in March. He says.
I'm asking
I
it on
understand.
academic purpose. Because I can understand, no, she's not in a position to take care of herself, and court is providing the legal expenses.
True.
She has come to the court. She's earning. She's in a position to engage Mr. Arun Govindraj as an advocate. So why should there be 20,000 as legal expenses?
It should have been more, man.
Agreed with orders passed in. The parties are referred to as wife and husband for the sake of convenience. MC number 8026 of 2023 is 2023 is filed seeking divorce by the wife. In that she filed an application under Section 24 of the Hindu Marriage Act, seeking direction to the husband to pay a sum of rupees 1,73,000 per month towards the maintenance of towards her maintenance and her minor son, apart from one-time litigation expenses of an amount of rupees 2,50,000. The court, by order impugned, had granted an amount of rupees 25,000 per month towards interim maintenance of the minor son from the date of application till disposal of the petition. And as far as the wife is concerned, she asked for herself also. That was rejected, and also directed to pay one-time litigation expenses of an amount of rupees 20,000. By passing this said order, the court had observed that the income of the wife is rupees 1,60,533. And the income of the husband is
Para 16, my lord, 1,21,220.
1,21,228.
Hello, sir. From our office, there is echo of that
No, you can
proceedings.
mute, you can mute
I
his.
muted. I am going to mute. He is going to unmute.
No, my lord, I wanted to make a submission with regard to compliance with visitation that has been also ordered, my lord.
In this order,
Yes, because this is a maintenance, and on the previous date of hearing, the counsel for the respondent has said that it's been a tit for tat, that the non-compliance of the maintenance has been leveraged to not utilize the order for visitation. So since that was a submission made on the previous date of hearing, I would like to make a submission that the respondent comply with the visitation order too.
no, we'll observe that also.
Absolutely.
He'll pay the maintenance, you give the
Absolutely.
visitation.
Lordship, I record my submission.
And income of the husband is 1,21,228. The court has considered the amount that has been spent by the wife towards a minor child, towards the school fees, general expenses, school uniform, transportation, recreation, extracurricular activities. And where an expenses of 50,000 is shown by the wife. And the court, considering all these expenses, had granted an amount of rupees 25,000 as maintenance to the child and 25,000 and 20,000 towards the litigation expenses. Learned counsel appearing for the petitioner submits that when the wife is earning 1,60,174 and the husband is earning 1,21,228, court ought not to have directed the husband to pay an amount of rupees 25,000 towards the maintenance of the child. Considering the parity between the salaries of both the parties, the court ought not to have granted the maintenance of an amount of rupees 20,000. Further, it is submitted 25,000. Further, it is submitted that when the wife has instituted the proceedings, when she is financially when independent and earning an amount of rupees 1,60,174 towards the maintenance, the court ought not to have granted an amount of rupees 20,000 towards the litigation expenses. Learned counsel for the petitioner further submits that when the wife on one hand is seeking maintenance and on the other hand is not complying with the order of visitation that is passed by the court. Next para. Learned counsel appearing for the respondent submits that the court has respondent wife submits that the court had rightly granted the maintenance. Further, it is a responsibility of the husband to take care of the needs of the child. When the wife, and just because the wife is also earning, the husband cannot shy away from the responsibility of maintaining the son. It is submitted that there is in the court had passed an order whereby the husband is restrained from sending any
emails.
Time or no emails at all?
No email, because he was sending emails every single day. Court, he gave an undertaking before the court that he will not communicate, he will not send any emails with regards to their personal matters. For visitation, we have no objection for him to send emails.
Except with regard to the child.
Yes, visitation.
Except with regard to the visitation, the husband was restrained from sending any emails, and he has also undertaken before the court that he would not be sending any emails other than pertaining to the visitation. But in spite of the same, the husband is continuously sending the mails, and the learned counsel has placed before the court the email communication which was sent to the wife immediately on the same day when what is the date?
2nd of July.
On 2nd of July when the hearing happened in this court. Then this court he submits that when there is an order by the court, when there is an undertaking, still sending these kind of messages shows the attitude of the husband and how he is violating the orders of the court. In response to that, learned counsel appearing for the respondent appearing for the husband submits that he had discussed the same with his client, and client has stated that he will never send these kind of he will never send the emails to the wife other than pertaining to the visitation, and he will abide by the undertaking that is given before the court. Next part. Having heard the counsels on either side, produce the material on record. Undisputed facts are the wife's income is 1,60,174 and the husband's income is 1,21,228 as per the order passed by the family court. The court, considering the 50,000 income as put forth by the wife, had granted 25,000 maintenance towards the child. The contention of the husband that as a wife is earning more income, the court ought not to have granted 25,000 as maintenance. The said submission, this court is not able to appreciate. When the wife is taking complete care of the child and taking care of the child, and the court, looking at the income of 1,21,228, had granted only 25,000 as maintenance, and just because the wife is earning, the husband cannot submit that he will not pay that much amount or the said amount is excessive. In the considered opinion of the court had rightly granted 25,000 as maintenance, and this court finds no reasons to interfere. Then coming to the litigation expenses of 20,000 are concerned, when the wife is earning, she initiated the MC 8026 of 2023 seeking the divorce. The court ought not to have granted the litigation expenses of 20,000. Then counsel for the respondent submits that already the husband has paid 20,000. The said amount shall be adjusted in the maintenance that is to be paid to the wife. Then coming to the submission with regard to the visitation and the mails are concerned, the husband shall not send any communication to the wife if it is brought to the notice of the court, again that he, in spite of an undertaking given before the court, the husband is still sending emails to the wife, the family court shall take appropriate action against the husband. The husband is paying the maintenance to the wife. The wife shall also abide by when the husband is paying the maintenance regularly, the wife shall also abide by the order passed by the court and shall provide the visitation to the husband. Accordingly, the petition is disposed of.
Obliged. Much obliged, my lord. Much obliged, my lord.
Yes.
27, Sachin BS for
But
petition.
to file, my lords, the statement of liabilities and assets. But as per this honorable court's order, my lords, because in the trial court, my lords, the husband has not filed the assets and liabilities. But for that, my lords, our contention is that, my lords, we are only a day.
What is the order in the RPFC?
My lords, the order, my lords, that is passed is in the 125 proceeding, 9,000 rupees, my lords, to the daughter.
9,000?
9,000 rupees from the date of petition. To the daughter, my lords, petition number, respondent number 2. Lords, the wife, my lords, insofar as wife, my lords, is rejected, my lords, on the ground that she is sufficiently income, my lords.
How much you sought for both? For wife, how much?
My lords, she sought 25,000 for both of them.
For both of them?
For both of them.
Court granted 9,000 to the daughter, but no amount to the wife.
No amount.
That you are questioning, or you are seeking enhancement for daughter also?
No, my lords. I am the husband's petition, my lords.
This is husband's petition. You are questioning that 9,000 that is granted to the wife?
Lords, on the ground that I am a daily wage worker. Lords, I have no sufficient income, my lords, to give 9,000 to the wife, to the child, Lords, in the criminal MC, my lords, in the DV Act proceedings, I have been giving 3,000 to the wife, which amounts, my lords, 12,000 in total, my lords, to the
What
wife.
is the age of the daughter?
My lords, now around 3 years.
4 years.
4 years.
You have not filed your statement of asset liability.
In the trial court, no, my lords.
Why?
Lords, I have not filed, my lords. I no reason. That is why, my lords, this court.
So that's why the adverse inference has to be drawn and court has granted. And what is the reason for this court to interfere?
Lords, this court, my lords, has ordered, my lords, to file assets and liabilities. Lords, we have called the client, my lords, he has not come. 2 weeks time, my lords, I'll file a.
No, why your
Page
client?
5 of the petition.
1 minute. Why your client is wasting the court's time? That I'm not able to understand. Why when there is an opportunity given, why is he not doing it?
Lords, I seek for a week's time, my lords, I'll file it, my lords. Otherwise, I have no case, my lords, without filing of assets and liabilities.
Both the parties are directed to furnish
Please,
assets and liabilities and income details for disposal of the matter.
We have already filed our
Now,
assets and
from here onwards, standard order for everyone who do not choose to file statement of assets and liabilities before the trial court, no opportunity in the high court. That will cut all the problems and all the pendency.
Page 5 of the petition may be seen, Lordship. Para 10. They themselves have stated that.
Page number?
Page number 5, para 10 of the petition, Lordship.
1 minute. Petition is at which? What is the page number?
Lords, the petition starts at page number 1. Lords, the grounds they are stating.
Oh, he means to the
The grounds, page number para 10, Lordship. The petition says it is submitted the petitioner has completed PUC and doing car washing and service business and sand business, Lordship. They themselves have stated they have many businesses that they are running. Now submitting
You see
and
the
stating
petition
that
and working in IT company and his gross salary is 23,000 per month. What is this?
Lords, that, my lords, is the, my lords, there is some, lords.
Lordship, now submitting that they are a daily wage worker is completely a false statement. Also, Lordship.
Lords, the submission, my lords, that it is the submission of the respondent that had to come, my lords. By mistake, my lords, it is submitted.
Petitioner who has a sand business, Lordship. Even before the trial court,
Please show me,
Lordship.
sir. Please show me that we have said that.
No, it is
Lords,
clear.
it's a wrong submission that is made.
Lordship, para 10 is clear, Lordship. It is submitted.
Please come. That's why I asked, where is the petition before the court? That
My lords,
objection.
the petition, my lords, is here.
No, without that, it is numbered.
Please, my lords.
Without filing the petition objection.
RPFC, my lords,
RPFC
the
para
petition
10,
is not
Lordship.
required.
Where is it?
RPFC para 10.
It is not there. He's giving it.
RPFC.
Sir, RPFC, that is what I'm telling you. There is a factual mistake in the pleading.
Where are your objections? Objections are also here.
Please. Lots of objections. My lords may see page number 16 of the petition, my lords.
You're earning 15,000 according to you.
Please, my lords.
You're earning 15,000 according to you.
Lords, that is, my lords, as per the daily wages, 300 rupees per day.
300
to 500, 350 rupees per day.
It's 150 for fuel expenses.
Please. That is what, my lords, my contention is before the trial court also. That is, my lords, the submission of the respondent that have come here, my lords, it is like in the grounds.
So then what is that you're ready to pay? You have to pay something to the daughter?
Lords, I am ready to pay, my lords. Lords, now what the situation is? Lords, 9,000 to the daughter. 3,000, my lords, to the wife in the DV Act case. My lords, it amounts to 12,000 rupees of the, to both, my lords. Whereas, my lords, I am earning 15,000 to 20,000, for example, my lords, I'm ready to pay 7,000 at least, my lords, to daughter. I have no issues because, my lords, I understand she is now 4 years of age. I have filed a GNW case, my lords.
You will pay 7,000.
7,000.
Yes, we'll confirm that. 7,000.
Okay. Should maybe increase, Lordship. Now, since the.
Where is your IA? Where is your petition to increase?
We'll submit.
What submit?
We have filed our objection seeking for the same.
No,
Lordship.
if you're seeking
Also-
enhancement, there
also,
should be a
Lordship.
petition.
Lordship.
You have not filed the RPFC.
Also, Lordship, one more aspect I would like to produce before this court, that they have approached this honorable court with unclean hands, Lordship. In the petition itself also, they have approached and taken an interim order stating that both the orders were against the respondent number 2, Lordship. It is only now they are submitting that the rupees 3,000 was submitted as to the respondent number 1, and then subsequently for respondent number 2, Lordship, 9,000.
My lords, that, my lords, it's all
Them
leading
themselves,
mistake.
Lordship,
If I
they
want,
have
I am
always
ready
been
to
submitting,
amend
Lordship,
the
before this
petition.
court. RPFC petition may be seen, Lordship. It's clear that they are submitting
Please come.
statements which is
Agreed with orders passed in criminal misdemeanor number 77 of 2022, dated 18 July 2023. The petitioner father is before this court. The respondent wife had filed the MC seeking maintenance of an amount of rupees 25,000 to herself and to her daughter. The court had rejected the application of the wife and granted maintenance of an amount of rupees 9,000 per month to the daughter till the date of attaining the age of majority. Aggrieved thereby, the father is before this court. Learned counsel appearing for the father submits that submits that he is working on a daily wages of the 350 and fuel expenses of 150. That has been stated in his petition. And with that wages, he is already paying an amount of rupees 3,000 as ordered by the DVC court to the wife. And now if you paid 9,000, they would be left with no amount. All these aspects were not considered by the court. It is submitted that the court, having observed that what is the income of the husband in spite of the same, had granted maintenance of 9,000, which is on the higher side, and the same needs to be reduced. Learned counsel appearing for the respondent mother submits that the court had granted the reasonable maintenance for the daughter. The petitioner has failed to file a statement of assets and liabilities. When she has failed to file the statement of assets and liabilities, it is not open for him to come and contend before this court that he is not in a position to pay and the amount that is granted is reasonable and no interference is called for. Next para. Having with the counsels on either side, there is a material on record. It's an admitted fact that is paying already 3,000 to the wife, and the court had rejected the request of the wife as she is earning and granted maintenance of 9,000. It is the case of the husband that he is a daily wage laborer. Then during the course of the hearing, learned counsel for the petitioner had submitted that he is ready to pay an amount of rupees 7,000 as he is already paying an amount of rupees 3,000 to the wife. This court has perused the order and also the submission of both the parties, considering, and this court deems it appropriate that an amount of rupees 7,000 would be reasonable under the fact and circumstances where the husband's income itself is 350 and 350 daily wages and 150 is towards the fuel. In that view of the matter, the RPFC is partly allowed by modifying the order dated so and so, and the amount of maintenance is reduced from 9,000 to 7,000. Yes, next.
Number 28.
In this offer for petitioner, my lord. This petition, my lord, this petition is filed by the wife, my lord, for against the order passed by the petition in CMIS number 307/2022, where our petition came to be dismissed.
I think this is in Kannada.
Order, impugned order is in Kannada, my lord. I have to translate it. I will file necessary translation.
What does this matter? after 4 weeks.
Cell
Yes,
number
next
29.
29.
The date may be fixed. Date may be fixed, my lord. Date may be
This is matter on 4th of August. Yes,
I
Great.
prefer a respondent wife, my lord.
yes.
I prefer for the husband. File the petition.
What is the urgency? Who moved the memo?
They have moved the matter, Your Lordship.
No, there are all these days,
Because
they are
we have-
saying that they are going to settle the matter, they will pay lump sum and they will get rid of.
And we have already filed the MC
They
case,
are
Your
not
Lordship.
ready to, they have come here and mediation is over.
No, let's please come to the impugned order.
Lordship, we have filed the MC case also, 3516
Let's
of.
look at the impugned order first.
Pardon?
Impugned order, where is the impugned order?
In order, they have not submitted, I think, only the,
Impugned order is already submitted and filed.
only the order sheet they have submitted, they have not submitted detailed order, this page number 32. Ink page number 32.
Order. 20,000 they have shown that on that account, Your Lordship. They have filed the.
What is
case
this
for
order?
conjugal rest.
There is no discussion in the order.
There is no
So
discussion.
that, the discussion, they have not submitted, their petition, the detailed order, they have not.
It's the order. What else they will submit?
No,
It's the order passed by the court.
That the order pronounced in open court, separate detailed order. Separate detailed order, there will be some,
Where do you get that? There is a separate detailed order.
they are not submitted,
Huh?
only the order sheet. They have not submitted.
This is the order passed by the court.
You
And
submit then.
Detailed order.
If there is, you submit the order.
I will
Yes,
find out.
please
Yes,
submit the
now
order.
this,
We'll see. This
restriction
is
of the
matter.
copyright. Next
After 2
week, my lord.
weeks,
Next
then
week.
counsel for the petitioner respondent submits that the order that is passed by the,
There may
that
be
is,
separate,
that is placed before this court is not the detailed order. There is a detailed order and he will submit.
if there is any,
There is, yes.
by next week.
List this matter after 2 weeks.
Cell number. List
interim
number
order
2.
extended. Your Lordship.
Interim
He has
order
not
granted is
deposited the earlier last
Yes, next.
few months.
Cell number 1.
Yes.
Copy issued.
Copy has been served.
Yes.
Respondent, chief time you.
Non-filing of acknowledgement for having served copies on the respondent served.
Yes,
Today has been,
2 weeks
Sir?
time. 2 weeks time.
copy has been served.
It is submitted by the land council that already the papers are served. Then notice to be served to whom? Await service of notice.
No, my lords.
Only one respondent.
First respondent, my lord, awaiting this.
Who is the first respondent?
First respondent is the owner of
Liability is on whom?
the claim petition has been dismissed.
Huh?
Claim
Claim petition
petition has
is
been dismissed.
post after service of notice
Please.
on respondent number 1. Delete from the caption for dismissal. Next.
Cell number 2.
In this case, my lord, yesterday I am not able to come to court, my lord. Officer
With the office objection within a week.
filed LR application, my lord, today.
It is submitted that the LR application is filed. Notice.
Please, my lord.
Oh, LR application is filed by you.
Filed by LR as a petitioner for one of
Yes,
the
yes.
decisions.
Give that.
Today I filed, my lord.
You have not filed.
Today I filed, my lord. Today.
It is submitted that he is going to file the LR application today, list the matter day after tomorrow. Delete from the caption for
Already
dismissal.
filed, my lord. Today I filed, my lord. Acknowledgement I have. Sorry, my lord. Sorry.
It is submitted that he has filed it today. Ministry is directed to put up the same and list the matter day after tomorrow. Delete from the caption dismissal.
Cell number 3. For orders matter, steps to be taken in respect of R3 and 4.
It's for a week's time. Artists have taken next.
A week's time. Default order.
Cell number 4.
Offering for appellant, my lord, in this case,
Please publish.
R1 may be directed to take notice.
Who is R1?
I have filed the Wakam Challenge.
816, I am the appellant.
Yes, yes, Nirmala, Mrs. Nirmala takes notice on behalf of the, which respondent is R1?
R1 is the case that is similar.
R1.
R2 may be dispensed with.
Take the memo. A memo is filed seeking dispenses notice to R2.
Yes, my lord. R3, my lord, O Mahesh is appeared in the, in connected matter, my lord, in
No, I don't know, because his appeal has come for
So,
office objection.
please serve notice on Mo Mahesh.
Yes, madam.
A memo is filed seeking dispensation of notice to R2. Memo is taken on record and notice to R2 is dispensed with. In the connected appeal for
R2
R3,
dispense, R2 Millard.
R2 is dispensed with. In the connected appeal, R3, for R3, Mr. O. Mahesh appeared.
In my matter, R3 OMS Millard. In their matter, R5
The
is.
connected appeal for the very same respondent number 3, in the connected appeal, Mr. O. Mahesh has appeared. So the petition is directed to serve notice on Mr. O. Mahesh, print the name of Mr. O. Mahesh as advocate appearing for respondent number 3.
Yes, ma'am.
Yes, next.
In connected matters, Millard, I will take notice, ma'am.
In 4.1 and 4.2, for respondents R2, R1 to R5.
R5.
For R1 to R5, not R5.
R1 to R5, Millard. In
In
4.1.
4.1, R1 to R5,
Yes,
Mr.
madam.
Raghu R takes notice. Then 4.2,
R1 to R3, Millard.
R1 to R3, so it's Raghu R takes notice.
Much of it.
In the name of Mr. Raghu R. Next 6.
Cell number 5, Anil Kumar.
What is this?
We have settled the matter. Judicial order. In this case, my lord, the rider petitioner was not having a driving license. Therefore, court has taken 30% negligence.
Give the file.
It has to be considered at 10% now, my lord. And disability has to be reconsidered.
Let's look at the order. Please come to the order.
Page number 17, para 12, my lord.
17.
Reasons.
What it says?
Rider, two-wheeler rider is the appellant is the two-wheeler rider, madam.
16.
Paragraph number?
Paragraph number.
Therefore, it is clear, crystal clear.
JCB driver had driving license as on the date and time of RTA.
Please.
Both drivers did not have a valid license, my lord.
What are the vehicles involved?
One two-wheeler and a JCB.
Your client is
Two-wheeler.
It's a case of death or
Injury, my lord. Head injury.
So both the claimant as well as the JCB driver are not having driving license.
Therefore, 30% negligence on the part of the
Claimant.
rider of the motorcycle. Now, my lord, only on the ground that he is not having a driving license. In one of the apex court judgment, my lord, now we come to conclusion. Instead of 30%, it is 10%.
What is the judgment?
Judgmental there is no
Supreme Court judgment to that extent. Negligence, whether the negligence on the court has to look into the negligence. Not possessing the driving license is not the sole reason to fix the liability, the negligence.
So how the manner of accident has to be taken?
Please.
So it has to be 10% now.
10%.
Then come to the, that is one aspect. Then come to the calculation.
Aspect is, my lord, doctor has assessed the disability of the, it's case of head injury. 55% disability was assessed by the doctor.
It is taken 1/3. Huh? It is taken 1/3. Okay. Now please come to the, yes, let's come here. So pain and agony.
Pain and agony, my lord, court has pain and suffering 60,000 is granted, another 20,000 we are increasing under that.
That is 20,000. Then medical expenses as it is.
Same.
Amenities 30,000 is granted.
Food diet same. How many days?
Same.
25,000. Then loss of income during the later period, how much was taken?
28,500 is granted. Another 9,500 to be granted.
It becomes how much?
38,000.
38,000. 38,000. So why, on what basis it is increased to 9,500?
9,500 is the income. 3 months.
What was taken by the court?
2 months.
3
months. How do? 28,000 is granted.
Court has taken 3 months, my lord. Now it has enhanced for 3 months. The additional 1 month, my lord.
4 months.
4 months. 4 months.
Next, towards permanent disability. Now, what is the calculation now?
40%.
1 minute. 9,500 into 12. What is the multiplier?
Multiplier is 18 million, age 19 years.
18 into disability is 55.
40%. Now it has to be reconsidered. Tribunal has taken 18%. Now.
No, it is like this. Either it has to be 1/3 or it has to be as it is. What is this via media calculation?
He is requested.
No, Milord. Not only 18 years, the disability which is assessed by the doctor is on the ISR considering the nature of injury. Therefore, Milord, 50%, 55% to the disability assessed by the doctor is on the ISR. Therefore, we have taken it is 40%.
Where is that discussion?
It is not discussed.
No, the problem is if it is going to be referred to the Lok Adalat, whatever you say, that the court will consider. Correct. But when the court has to give some
32.
finding on that.
Para 32 million.
32. Please read.
With regard to permanent disability of his eyes, that petitioner has examined Dr. Satish K, eye specialist, as CW1. In his evidence, CW1 has stated that he has treated the petitioner as at JSS hospital and states that he met with a road accident on 13/3/2016. CW1 further states that the petitioner was brought unconscious state with the GCS of E1, V2 and MS. CT scan source SDH in right eye.
Ataxia, disability, 25%, intellectual impairment, 71%. It comes to 55%.
Please.
Yes, sustained vertebra fracture.
Produce
for vertebra and other body fracture is concerned, Milord.
So now you are okay with this with 40%?
Please.
How much it is coming to? 9,500 into 12 into 18?
3,000. No.
Where did you say so?
Total 11 lakhs, 49,000. 40% has to be.
Oh, so it comes to now 9,500 plus 40%?
13,300.
Huh?
13,300.
13,300 into 12 into 18 into 40 by 100.
Please.
It's coming to?
11,49,120.
It comes to 11 lakh
49,120.
49,120.
Please.
Then disappointment and loss of immunity is 30,000.
20,000 addition we have granted, so 50,000.
50,000. So how much is coming to?
Totally it is put together 11 lakh.
No. 15 lakhs,
60,000,
15 lakhs?
60,000. 797.
797. Then in that?
Less 10%.
10%. 10% will be 1,56,000.
Please.
79.
So what would be the amount?
14 lakh 4,713.
14 lakh 4,000.
4,713.
713.
Less awarded amount of 5 lakh 12,070.
I'll record like this. Please come. Agreed by the. Is it recording? Switch on it. That's more easier for you.
Dispensation.
Switch on that no, so that it will be recording. She's saying it's not recording.
Madam,
why they are not using? Let Bindu do in the meantime. Let her do, let Bindu do. Yes, please come in. Agreed with the award passed in. MEC number 433 of 2016 dated 13th October 2021, whereby the court had granted, the tribunal had granted compensation of an amount of 7,31,537 and 30% was taken as contributory negligence. The claimant is before this court. Then counsel appearing for the claimant submits that when the doctor had a doctor has given the evidence, the evidence that the claimant is suffering with 55% disability, where he has lost the eyesight and the intellectual impairment. The court had taken the disability at
18%.
At one third of it at 18%, which was not correct. It is submitted that both the claimant as well as the driver of the JCB were not having the driving license. The court had fastened the contributory negligence at 30%, which is on the higher side, and that is contrary to the judgment of the Honorable Apex Court. It is submitted that on other heads also, the compensation that is awarded by the tribunal under the head of pain and suffering, for the food, nourishment and conveyance is on the lower side. It is submitted that loss of income during the treatment period, court had granted only for 3 months. It should have been for 4 months. Further, the court had not granted future prospects.
Please.
Court had not considered the future prospect, considering the injuries sustained by the claimant. And even under the head of loss of amenities also, the amount that is granted by the tribunal is on the lower side. Then counsel appearing for the insurance company. Your name is there, Mr. Sivanagoda? The then counsel appearing for the respondent insurance company submits that the court had rightly considered all the aspects and had rightly granted the compensation. It is submitted that as both of them, both the driver of the JCB and the petitioner not having the driving license, the court had considered the contributory negligence as 30%, which is just and reasonable. He submits that there are no interference is called for with a well-considered order passed by the tribunal. Next one. Having heard the counsels on either side, peruse the material on record. The claimant had sustained the head injury
Stated in
STH in right high parietal convexity with streaks of SAH extending to tentorial cerebrally. The fracture of left transverse process of C7 and T1 vertebra. Fracture of the left clavicle. Fracture of left apical, you will get it at page 24. Fracture of left apical pneumothorax, grade 3 and 4 pelvic laceration. And along with that, he has sustained other injuries. In the considered opinion of hence this court under the head of pain and suffering is inclined to grant an amount of rupees 80,000. Then towards the medical expenses, court has rightly granted the compensation. There are no grounds to interfere. Then coming to the food, diet, nourishment and conveyance, considering the hospitalization, this court is granting an amount of rupees 50,000. Considering the income at 9,500, the court had considered only 3 months. This court is considering for 4 months, and the court is granting an amount of rupees 38,000. Coming to the permanent disability, the doctor had opined that it is 55% disability. Court had taken 1/3 of it, considering the head injury and the physical and the intellectual impairment. This court is inclined to consider the disability to the whole body at 40%. The accident had taken place in the year 2016, as per the table prepared by the Legal Services Authority. The court is taking the income at 9,500 and considering the disability, the future prospects at 40%, it will come to 13,300 into 12 into 18 into 40 by 100 is 11,49,120. 120. Then towards the loss of amenities, considering the injuries, this court is granting an amount of rupees 80,000. The total compensation comes to 11 lakh. The total compensation comes to 15 lakh 60,797. Now coming to the contributory negligence, just because the driver of the claimant is not having driving license, that itself cannot be the ground for the court to fix the contributory negligence at 30%. This court, having perused the order and having perused the order and the manner in which the accident has taken place, this court is taking the this court is inclined to fix the contributory negligence at 10%. In that case, the 10% would come to 1,56,797. Then the claimant is entitled for an amount of rupees 14,04,713. Accordingly, the appeal of the claimant is allowed by enhancing the compensation to 14,04,713.
Yes.
Huh? The tribunal has already passed an order of pay and recover, and as such, the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. You will have a format for our orders. Take that and do. Yes, next.
Percentage.
A memo is filed seeking dispensation of notice. Now, when the pay and recovery is ordered, how can there be a dispensation? Huh? That is not what is stated here. You give the other memo.
Please.
Give the other memo, write the memo and give. A memo is filed stating that the owner of the vehicle is set ex parte before the trial court. As such, the memo is filed seeking a dispensation of notice to R1, the owner of the vehicle. Accordingly, memo is taken on record and dismissal. This should be the docket order. Yes. Where is it? Where is that IA? Where is that? I don't see the IA here. This should also be a docket order. And in the main order, in the points, it should be reflected because how much is the delay? Anyhow, we'll condone it. Only 152 days. I number so and so is filed to condone the delay of 100 and where do you get? Where is that? To condone the delay of 152 days for the reasons stated in the accompanying affidavit, the delay is condoned. Yes, next. Yes.
Lord,
XM Joseph for petitioner appellant.
Lord, on 8/4/2024, this court had granted a stay directing the appellants to deposit 50% of the award amount. Thereafter, the appellant was not able because he was admitted in the hospital. So we filed an application to extend the interim order and to file to deposit the 50% of the amount. Came to be allowed. Thereafter, my lord, on 28/10, the remaining balance, we filed an IA to file a remaining balance amount to be paid. In my IA, my lord, at page number 10.
Who passed? Give that order sheet.
My application, my lord, page number 10.
When did you file the application?
My lord, even after depositing, my lord, the execution proceeding is proceeded, my lord. Even after complying this order by deposit, your lordship
There
gets
is a stay of execution.
It was on 8/4/2024, my lord. There shall be a stay of operation and
1
execution.
minute, 8/4/2024.
Please, my lord.
There shall be stay of operation execution so and so. Appellant shall deposit 50% of the award amount within a
Subject to
period of
condition.
4 weeks. Please wait.
Please.
Now, 8/4/2024 is the order.
Please, ma'am.
When did you deposit the money?
On that occasion, we did not deposit, my lord. So
When
we
did you
thought-
deposit?
We deposited on 27/9/24, my lord.
27/9/2024.
my lord.
Where is that order? No, this is a conditional order. It has gone.
Please, my lord.
So now you can't rely on 8/4/2024 order at all.
No, it was a continuation, my lord.
No, why? How can it be a continuation?
Because we sought for extension in on.
Where is that? That's what I'm asking you. Where
That
is
is
the next
on-
order?
14/8/24, my lord.
14/8/24.
Third paragraph, madam. IA number 1 of 24 is filed seeking the court to extend the time of depositing the amount as ordered by this court through order dated 8/4/2024.
When was the execution?
Execution filed, madam.
Why when the order is executed?
Madam?
I'm asking,
Please.
when did the trial court execute the order? Executing court has executed the order.
The execution proceedings, my lord. It's goes on. (18/4/23), my lord.
18/4/23. So
The
you're
execution
saying
proceeding.
that in spite of an order of this court, the court has executed the award. What
It
you're
is not
saying?
executed, my lord.
Then
Execution proceedings was filed. So we have stayed the proceeding on 8/4/24. It was stayed, directing us to deposit 50%
I
of this.
understood. You
Please,
made a submission now.
Please, my lord.
Before this, you are saying that in spite of an order passed by this court, still the executing court was going
Please, my
ahead
lord.
with the execution.
Your lordship gets at page number 11 of my application, my lord. After depositing the remaining balance.
Where is that? 11?
Page number 11, my lord.
Page number 11.
Of the application, my lord.
That is numbered as?
Page number 11, my lord. Application, IA number 1 of 2025.
2025.
Please, my lord.
How many IAs are filed?
No, my lord.
1 of 25. What is this application?
Lord, page number 10, your lordship gets advocate for JDR filed a memo, produced DD of rupees 5 lakhs, which is.
Page 1 minute.
Please.
Page number
10, my lord, of my IA.
When is this? 19/10/2024. Now, this court.
Please, my lord.
Please come to the order of this court.
Please, my lord.
When the time is extended to you. That
Lord, it
is
was
on
extended.
14/8.
14/8.
14/8/2024.
Please, ma'am.
So it could deposit the amount. What is the time? 2 weeks. So
Please.
2 weeks from when, that is 14/8, another 2 weeks. Even if I take 1 month, it will come on
Well,
14/9/2024.
I had applied certified copy on 4/8 14/8/2024, my lord, but I received on 2/9/2024. That is a certified copy which I received, order of dated 14/8/2024.
You are aware of the order, isn't it?
It was not published in the website, my lord. That is the reason your lordship gets it at page number 12.
I cannot find fault with the order of the
No,
court.
my lord. I'll point out, my lord. Even at page,
No,
page
you are
number 14.
getting, no, you are getting an order that is passed in the month of, when is the initial order? From there on, for various reasons, why should
My lord,
you?
after depositing,
No, you should have
they
shown
say
your
the above said
police.
order is noted and verified, found that the DD bearing so and so for submitted by the JDR 4/11/20 is not handed over to the accounts branch. Your lordship gets at page number 14, my lord, in my IA. They have not.
What to do now?
Thereafter, they proceed, my lord.
Let them.
Issue say, lord. Even after depositing 50%, my lord.
It is not at your convenience whenever you feel like.
No, my lord. Even the certified copy which I've received was on a delay, my lord. Kindly see, my lord. Both the certified copies, because even otherwise, my lord, your lordship gets at page number 12.
Now you are present in the court.
Please, my lord.
Court has granted you 2 weeks time.
Please,
Are you not supposed to?
First of all, the trial court seeks an application which has not been uploaded in the net also, my lord. So we applied for.
What did you do? Did you not? Have you not come to the
we
court?
Have intimated, my lord. We have intimated. That is the reason. Thereafter, that is why the trial court also accepted. They have accepted because of the delay. They have accepted both the DDs. One is 5 lakhs and one is 1,24,000.
Who is AP? Your AP. Why the intermodals will not be uploaded immediately? Huh? I mean, that's what he's saying is it is not uploaded. Check it. This 14/8/24 order. How can it be? Why it won't be uploaded? Look at ask Bindu to verify. When is the order uploaded?
Both these certified. Thereafter, my lord, after depositing, the court directed us to produce one more certified copy of the order. So at page number 12, you get, lordship, advocate for JDR filed a memo to produce certified copies of the order of MA after depositing both the DDs. Thereafter, the DD is misplaced by the.
But there is no stay order for further steps by 29/1.
No stay order. That is. Again, my lord, page number 13. Advocate for JDR filed an application, got it advanced the case, filed an application to stay the execution petition as per the order of the Honorable High Court of 8/4 at bottom line. But the JDR did not comply the order of the Honorable Court, hence the application. After taking it on record, and the mistake is on the at page number 14, they have not sent to the account branch. Thereafter, it has been issued.
I'm not able to understand what you are submitting. At 13, nothing about the DD, nothing about anything.
It is given, my lord.
Only what they said was an order is passed by the court, and that is not in force now.
Next page, my lord, 14 here.
Yes.
The above said note is verified, found that DD bearing so and so for rupees 1,27,000, that is the balance amount, submitted by the JDR on 4/11/24 is not handed over to the accounts branch by the case worker by oversight.
Which date it is uploaded? Huh? Same date it is uploaded.
Same date I have applied, madam, but I have not received.
It is uploaded in the that's
Please,
available.
I'm having that.
Not that copy. Online copy is available.
Please, it was not uploaded, my lord. That is the reason.
That's what it shows.
That is why
from the
trial court has also sought. We have filed a memo to file the certified copy also.
No, something is wrong with this process of uploading. Stenographers are not uploading the orders at all.
Otherwise, so I would have
though
not filed
the
memo.
court is signing. I'm in our court. How many times I have found today one case of Bindi also. Why they are not uploading? Who will verify that?
Both the orders, my lord.
I'm not telling you. I'm
Please,
listening to her.
my apologies.
Huh? Then tell the registrar judicial, it's a duty of every stenographer to see what all the orders that they have taken or they are uploaded or not. Otherwise, every order that is signed is not being uploaded. Then what is the purpose of signing the orders on the same day? Yes.
Even otherwise, Account, it was not handed over to the account branch, so they asked for a one more fresh DD. my
Now
lord.
you got, when is the impugned order?
Lord, impugned
Impugned
order.
order is the order where the award is passed.
Passed, my lord. Same court, my lord.
Which date is the
Date
order?
is 13 December 2022, my lord.
So from 13 December 2022, happily you are enjoying till 2024 without doing anything.
No, even he has been admitted because he is having memory impairment of 60%. So his son has a special GPA to this petition, my lord.
So what happened to son? Son is fine.
Son is fine, my lord. He was admitted. That is the reason we filed one more IA on 14/8. This said.
No, when an order is passed on 13 December 2022, what are you doing till 18/4/2024? That is already there. 2 hours delay is there. 2 years.
No, it was on time, my lord. Delay. We had filed the delay application also, my lord.
So at every time.
Appeal was on time, my lord. Appeal was on time. There was no delay. Okay, lordship gets it.
How much delay you have filed?
But we thought there was a delay of some 12 or 13 days, thinking, because calculating even the Sundays or something. But appeal was on time, my lord. So now what they are saying is, after taking the amount, they wanted a fresh DD on, that is on the 17/3/25.
What is the award amount?
Award amount is 12 lakhs 54,844.
What would be the 50% of it?
6 lakhs 27,422.
Have you deposited 6,27,000?
Full, madam. That is why 2 occasions we have deposited.
Who are you?
I am the driver, my lord, of the other vehicle. Respondents are the deceased.
Petitions are entitled to compensation of 12,44,000, 54,844 along with interest. Respondent is liable to pay compensation to the opposite vehicle which is not insured.
No, man. Both the vehicles are not insured. There is no DL to the deceased.
Let them withdraw this amount.
My lord, we have filed another petition which is pending in the same court.
What petition?
Same similar counter we have filed. That is still pending. It's they have never
for all this delay. I'll direct them to stall all the proceedings. Let them.
They have not even come before this court, my lord.
Let them. Withdraw
And the negligence is after giving the DD 17, they ask for fresh in the same court, and the judge records.
Then counsel for the petitioner submits that half of the awarded amount 6,27,000 is already deposited by the petitioner. In spite of the same, the court is proceeding with the sale of the property.
Please, ma'am.
Property. As the petition has already deposited 6,27,000, the respondents are at liberty to withdraw the said amount, and the executing court shall not proceed with the execution / sale of the property.
And we have filed a counter also, which is pending in the same court at the evidence stage.
Yes, next. Yes, next.
7. Then number 7 for acceptance of
Memo is filed seeking acceptance of the paper of application, and the same is accepted. Notice to R10 and R11 is held sufficient. Then, Mr. Sivanagada, what about YA 1 of 24? You are on liability.
release of
I number 1 of 24 is filed seeking release of the amount. Then counsel for the insurance company opposes the same, saying that they are on the question of liability. Accordingly, I number 1 of 24 is dismissed. Next 8. Memo is filed seeking dispensation of notice to R1 and R2 dispensed with. Who appears for the United? Where is that list? United India Insurance, you appear?
BC Shivanagowda. BC Shivanagowda, sir.
He also can appear. Yes, Mr. You are? Krishna Kishore is directed to take notice on behalf of the insurance company. There is this on condition I number 1/24 is filed to condone the delay of 570 days in filing the petition for the reasons stated. The delay is condoned on the condition that they will not be entitled for interest in case of the enhancement of the compensation. Yes, next.
My lords, matter may be referred to Lok Adalat.
It can be referred.
Please, my lords.
Today itself, we'll give the papers to him, we'll see.
Tomorrow, my lords. Tomorrow, my lords.
Why you don't have papers?
My lords, by mistakenly I have taken another file. My lords.
Tomorrow. List this matter tomorrow in the other list. That is the third list. List this matter. 8. Next 9.
Cell number 9. Cell number 9.
The appellant shall do the needful within a week, or appeal shall stand dismissed against all the respondents.
Number 10.
Yes.
Ravishankar Shastri.
Liabilities upon respond number 2, my lord, I have to take steps, lordship may
A
grant.
week's time, default order. Next 11.
Number 11. Memo for dispensation.
Yes, memo is filed seeking dispensation of notice to R1, dispensed with.
I appear for
It can be settled?
70,000. Already settlement. 70,000, my lordship.
It can be. Both the parties submits that the land counsel for the insurance company, Mr. Janardhan Reddy, submits that the insurance company is ready to pay an amount of rupees global compensation of an amount of rupees 70,000. Land counsel for the petition also submit that it's agreeable to the party. List this matter before the Lok Adalat on Thursday.
Please.
Yes, next.
My lord, next matter, my lord, respond number 2, kindly notice may be dispensed with, my lord.
Then in 12, have you filed a memo?
Yes, ma'am.
A memo is filed seeking dispensation of notice to R2.
Yes.
Same is taken on record and dispensed with at the risk of appellant. Yes, then what about this?
They have received papers. Thursday.
Not Thursday, we'll list this matter tomorrow.
Tomorrow, because I can't get it to papers.
Yes, Thursday. List this matter on Thursday.
Please.
Yes, next 13.
13. Cell number 13.
My lord, I am for appellant.
Seeking dispensation of notice to R1 dispensed with.
Then
Then what about papers are served on Mr. Shankar
Yes,
Reddy?
yes, served, he filed the wakalat also.
And counsel for the appellant submits that papers are already served. Admit post of final hearing, call for the DCR. Next 14.
Number 14.
List after service of notice.
Cell number
Awaiting, my lord.
Huh?
My lord, I have served the copy, my lord, and also filed the acknowledgement. Register, my lord.
About service of notice. Land counsel submits that he has already served the papers on the counsel for R4. Yes. Next 15.
15, my lord, I am for the appellant. Cancellation copy of the judgment, I'll take a chance after
Yes.
8 weeks, my lord.
This is
Because
matter
of this,
after
the
4
claim
weeks.
petition is dismissed.
Yes.
Dispensation, the judgment copy, certificate copy of the
Where is that?
original certificate copy connected. I produce the
Submission with
certificate. I
regard
have
to office objection, translated copy of judgment and award to be filed for dispensation or pending. What dispensation?
certificate copy of the judgment, my lord.
I number 1/25.
1/25 is for condonation of delay.
IA number 2/25 is filed seeking dispensation of filing the certified copies of the judgment. The same is dispensed with for the present. Next.
Take out notice, my lord.
Notice to
Respondents.
Yes,
Notice
issued-
was not ordered.
Managing director, then some no counsel is here. We'll ask them to take notice.
Please.
Who is the counsel? How
Counsel,
many
ma'am.
are the respondents?
IPCO Tokyo, my lord.
No, it says managing director and
IPCO Tokyo and manager BMTC one.
BMTC who appears. Nirmala appears for BMTC.
Please.
This Nirmala takes notice, is directed to take notice on behalf of the first respondent. Second is?
Second, take out notice, my lord, because of the claim petition dismissed.
Second is who?
The second is owner of the vehicle.
The petition shall take up for pay the process.
Third.
Already paid the process.
No, no.
Shall
I have to
shall
pay.
take steps in respect of respondent number 2 within a week, default order. Yes,
And R3 also is there. R3 IPCO Tokyo, another insurance.
who appears? If could of you appear? Mr. B. Sivanagod is directed to take notice on behalf of respondent number 3. The council shall serve the papers on the both council for the BMTC as well as the insurance company.
Please.
Yes, next.
Hearing on IA, cell number 16.
Appearing for the respondent number 1, your lordship. Serial number 16.
Yes. Are you on liability?
Please. Involvement of vehicle is interesting.
Itself is question.
Your Lordship, I filed an application to withdraw the said amount.
That's true, but when the liability itself is in question, we'll not.
With respect to that aspects, Your Lordship, they haven't filed any documents with respect to those aspects, Your Lordship. Since they're challenging the said liability of the said vehicle, Your Lordship.
Any fix, my
there's
lord,
no
after
cogent
the
evidence has
Adalat,
been.
we will address the argument.
The insurance company is questioning the involvement of the vehicle itself. At this point of time, this court cannot permit the claimant to withdraw the amount.
Why?
This is
Because, Your
matter
Lordship?
for final hearing on 11th of August.
Much.
Cell
Yes,
number
next 17.
17 Vijay Kumar ki.
Appellant, my lord. Trial court or record is awaiting, my lord.
In this case, my lord.
Sign 125 for release of amount.
Yes,
Yes, my lord. My lord, the appeal by the owner of the vehicle, my lord.
On the
Trial court record is required, ma'am.
No, that is true. They have filed relief for release of amount. On what ground you are before this court?
My lord, the tribunal, without affording an sufficient opportunity to tender the evidence, my lord, awarded the compensation.
You are on the quantum. You are on the
As
quantum.
well, because, my lord, the appellant, the respondent himself was a rider of the offending vehicle, my lord. The rider was implicated, my lord. One Guru Murthy, my lord. Challenging the liability also, my lord.
You have not filed your objections also to IA number 1 of, when counsel for the petition seeks time to file objections to IA number 1 of 25. This is matter after 2 weeks.
17.1, my lord. Claimant also filed appeal to serve copy on.
IA in next 17.1, Mr. Vijay Kumar T takes notice on behalf of the respondent. The counsel shall serve the copy of the appeal memo on the counsel. Yes,
Please, please.
18.
Please.
18.
Who appears? Bharti Aksa. ICSA. Sivanagoda appears. So, Mrs. Sivanagoda takes notice on behalf of the respondent insurance company.
R1, I take notice.
For R1?
I will take notice.
For petition shall take steps for issuance of notice to R1 within a week.
ICC Lombard company officers have come. Available case, I will settle the matter.
Pass over
the matter.
Pass over. 18 pass over. Yes, 19.
Cell number 19.
United Insurance.
United India Insurance, Janardhan Reddy appears. He appears?
Janardhan Reddy.
United India. Mr. Janardhan Reddy takes notice on behalf of the insurance company. Who are the other respondents?
I will take out notice on R1.
R1. For R1, petitioner shall take steps within a week. Default order. Next 20.
20.
Number 20 was case of injury. I seek dispensation for R1 and matter may be local less medicine.
Which is the insurance company?
He has discussed also.
India.
It will be so.
I have discussed this.
When? Now itself it can be done or tomorrow?
Tomorrow, let it be tomorrow.
Memo is filed seeking dispensation of notice to respondent number 2. Memo is taken on record and dispensed with the risk of appellant. Mr. Kishore takes notice on behalf of the respondent insurance company. List this matter tomorrow in list number 3.
Respondent number 1 is to be dispensed.
Respondent number 1. Yes. And respondent number 2, Mr. Kishore takes notice. List this matter tomorrow in list number 3. Yes, next.
Cell number 21.
My lord, this appeal is by the insurance company, my lord, challenging the ex parte judgment and award, my lord. Our vehicle is not involved in the accident. As per the FIR, my lord, it is an unknown vehicle.
Notice to the respondents.
Cell number 5.
Notice to the respondents. Yes, next.
For admission matter.
My lord, start first, they have filed the execution petition, my lord, in EP
They
number
will
13.
file if you don't do it from 380 days.
My lord, it is an ex parte judgment, my lord. It is an ex parte judgment and there is a.
Why you are not appeared?
Please, my lord.
Why you are not appeared?
My lord, no notice was served.
Without notice, why the court will set you ex parte? Give that.
Well,
give the papers.
that's what I have done in Mysore, my lord. That's what happened. Even you have given complaint to the registrar also.
Well, let us see. Let us see what has happened.
My lord, I am ready to deposit the entire award amount. I am ready to deposit the entire award amount. Kindly grant stay, my lord.
Just see what is the court's finding on your appearance and.
Please, my lord. Third and
the second respondent. Who is the second respondent in this?
My lord, that is Reliance General Insurance Company. Well, if the notice is served, why? What is the difficulty for us to appear before the court and contest the
That's what
matter?
we'll see what it
When
is.
number of matters are pending before the court and number of panel advocates will be there, the court should have taken directed any one of the panel advocate to take notice and contest the matter. The presiding officers also know who are all appearing before the court for particular insurance company.
In spite of service of notice, respondent number 2 remained absent. Consequently, it is placed ex parte. Then what did you say about this in your affidavit in this petition?
My lord, we have not received a notice. That's what we say.
Where did you say that?
If you are aware of the thing, we will engage advocate.
Unknown
We
delay
will go on with the
petition,
matter.
where is that IA? In what did you say in IA number 1 of 25?
Regarding we came to know about only the claimant advocate came and approached the insurance company to deposit the amount, saying that we have already filed execution petition. Then only we have.
What efforts are made by the insurance company to find out from the court what is the notice, when is it received and all?
My lord, you ask me, can appreciate when they come up with the execution petition, my lord, first of all, we will file the appeal and approach the court for stay. Then we will go all things, go to all those things.
That it is an ex parte order and no
Yes,
notice. It is as per the court, notice is served and the respondent remained ex parte. It is the contention of the learned counsel for the petitioner insurance company that no notice is served on the insurance company. During the course of hearing, if it comes to light that the notices are served on the insurance company, at that time of hearing, the court has to take this aspect into consideration. Learned counsel for the appellant submits that he is ready to deposit 100% the entire amount. On such condition, there shall be stay of all further proceedings and the claimant is at liberty to withdraw 50% of the amount.
With security, madam, with security. Furnishing the security.
Yes, next.
Madam, our vehicle is not involved in the accident. A complaint was given against unknown vehicle.
22, Your Lordship. 22. Srishaila already filed the appeal. My name will be deleted, Your Lordship, and Srishaila name may be shown. Because 5350 filed by Srishaila.
In 22,
company appeal.
Delete the
22.
name of Mr. Ravi Shankar for R2 and print the name of Mr. Srishaila as who has already filed other appeal, that is MFA number 5350 of 2018.
Yes, madam. I appeal for the appellant. Narasimhamurthy appears for respondent number 1 in his appeal, connected appeal. He may be directed to take notice for the client.
In 22.1, Mr. Narasimhamurthy GB is directed to take notice on behalf of the respondent and the appellant shall serve the copy of the appeal memo on the counsel. Admit post for file hearing. Call for the TCR. Look at it. TCR is there? It's not there. Call for the TCR. Yes,
Cell
next.
number 23. Cell number 23. N. Kumar.
Look at it. It's under MDC or the WC. MDC. Admit post for file hearing. TCR. Yes, next.
Cell number 24.
My lord, claimant's appeal on negligence aspect as well as on quantum.
Admit post for file hearing. Call for the TCR. TCR is already there. Admit file hearing. Yes, 25.
5. FS Gabali.
Admit post for file hearing. Call for the TCR.
Cell number 26. 26.
26.1 I pay for appellant, my lord. In 26.1, in that I have to take steps for answer.
R3 for second time. Counsel have a non-filing of acknowledgement for the in 26.1 in MFA crop. The counsel for the appellant shall do the needful within a week. Yes.
Raj K. 27. Raj K.
Same. Admit post for final hearing. 28.
28. United Insurance, take out notice of Ashok Patil.
Mr. Ashok Patil is directed to take notice on behalf of the respondent insurance company. And who are the other respondents?
R1 will take notice.
R1 for issuance of notice to R1. The appellant shall take steps. List this matter after service of notice. Next 29.
29.
All
final
these,
hearing.
in these matters, there is any scope for settlement that I'll will hear.
Hearing part of the
Orders will
petition.
adjourn the matters.
Waste time for
My lord.
In which matter?
29.
So 29, list this matter on 18th of August. Then 30th,
30.
B. Pradeep.
I am the advocate for the appellant. Your Lordship, if it will be taken tomorrow, I will be ready with the judgments also. 30.
Issue. 30th, list the matter on 19th.
Much of it.
31.
Well, 31, my lord, in the connected cross objection, my lord, I am filing the memo for dispensation of notice to R1, my lord. For R2, the other Nirmal advocate will appear.
Take that. In 31.1.
Yes, my lord.
In 31.1, a memo is filed seeking dispensation of notice to
R1, my lord.
R1. The same is taken on record and notice to R1 is dispensed with. This matter on 28th of August. Then 32. 32. List this matter on 3rd of September. Already TCR is here.
Yeah, common is
Yes, 33.
Appearing for appellant, my lord, quantum, my lord, challenging the quantum.
Who appears for the respondent?
I am appearing for the respondent.
Oh, United India Insurance.
Insurance company has also filed on the appeal, my lord.
On?
Insurance.
Only quantum.
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 Insurance company appeal only 33 years. United
Yes,
India
sir.
Insurance. Is there any scope for settlement? That's what I'm asking.
My lord, kindly have it tomorrow, my lord.
Tomorrow, 33 in the list number 3 tomorrow. Then
34 place for time, my lord.
34,
Place for a time, my lord. Girimalaya is not out of station.
Giri Mallaya.
Yes, ma'am.
Reliance General Insurance Company. Sriram, you're for Sriram. Reliance, no scope. What do you say? 34.
Reliance, they are not coming today.
They won't come.
No, they will come today. They will not.
When they are likely to come? Give a date. That day we'll post this matter.
I will inform them.
Any 34, list this matter on 22nd of August. Next 35,
35. R. Shashidhara
Ashok and Patil.
for R2.
This matter on 9th of September. Then 36.
36, it is liability, my lord. Owner's appeal.
I will appellant in this case, my lord.
36, list the matter on 10th September.
Much
37.
In this case, press for time, my lord. It is a grievous injury here by the court, my lord.
Managing Director KSR.
Yes, my lord.
List the matter on 10th September.
Please, my lord.
Cell number 38. 33.
This on 15th of September.
Cell number 39. Ashok and Patil. Kevin Asiman.
23rd of September. 4th.
My lord, I am for appellant, my lord.
Sriram General Insurance.
Which one?
40.
40, my lord, it cannot be settled because they are disputing the line.
40 on 16th of September.
Cell
Then
number
41.
Ravi Shankar CR.
23rd of September.
Cell number 42.
Pradeep, which is the insurance company?
Pawan Chandrasekhar.
42, which is the insurance company?
Future General Insurance.
Future General Insurance. This is a matter on 26th of September.
43. Admission at 2:30.
What is this admission at 2:30 p.m.?
Yesterday, your lordship has directed me to take notice. Srinivas, M.I. Srinivas.
This we will deal with it in
I
that.
have sent the message. I will receive the message in another half an hour. It may be a call at
Let it
2:30.
be kept like this. We'll call it in the afternoon. So the remaining matters after 2:30.
The same list, my lord.
Serial number list 3.
List number 2, serial number 18, my lord.
One minute, I'm here. List number 2.
Serial number 18, my lord.
What
I should
happened?
take notice to this issue one, good, my lord.
What happened now? 18, what has happened?
Liability issue is there, my lord.
Correct.
Notice to owner.
It's already over. What happened? I'm asking.
I'll take out notice to R1, my lord.
Ordered the notice to.
It is pass over, my lord.
No, it was, we have taken Passover in order to settle the matter. It is not settleable case. Notice has to go to the owner. Therefore, notice may be.
So, yes, please. Notice to order. Yes, next.
Please, sorry, my lord.
My lord, serial number, list number 3. List number 3, serial number 5, my lord.
The insurance company is here. Please wait till afternoon. If it is not settling, then we will adjourn it. In that, please don't mention anything in list number 3. Yes.
List number 4, my lords, I need to take steps. Can I seek for an? I'll take steps.
What's happening?
I need to take steps against the owner of the vehicle, my lords. So that is at serial number 22 in list number 4.
Liability is on the owner.
No, it is on the insurance company.
Then they're here.
Yes.
So because the insurance company is here, that's
I'll
why.
wait.
If it is like once we call the matter and there is no likelihood of settlement, we'll adjourn all the matters.
Please, yes,
so don't worry, please be there at 2:30.
Yes, I'm sorry.
ಹೌದು serial number ಎಲ್ಲಿಂದನೋ ಹೇಳೇನಪ್ಪ ಫೈನಲ್ ಇಯರಿಂಗ್ 29 18 ನೋಡ್ಕೊಳ್ಳಿ ನೀವೇನ್ ಬರ್ಕೊಂಡಿದ್ದೀರಾ ನೋಡಿ ಅಲ್ಲ 29 18 30th 98 31 28 8 32 39 33 97 tomorrow ನಾಳೆ ಕೊಡ್ತೀನಿ 34 22 8 35 99 36 10 9 37 10 9 38 15 9 30 38 15 9 39 23 9 40 16 9 41 23 9 42 6 26 9 ಅಷ್ಟೇ ಇದೊಂದು ಮೆಮೊ ಸೇರಿಸಬೇಕು ಮೇಡಮ್ ಇದೊಂದು ಮೆಮೊ ಕೆಪ್ಟಿಲ್ಲ ಅದು ಬೇಕು ಮೇಡಮ್ ಅಲ್ಲಿ ಫೈಲ್ ಬರ್ತೀನಿ ನಾನು ಫೈಲ್ಗಳು ಬೇಕು ಒಂದು ಡೇಟ್ ಮಾಡ್ರೆ ಕೊಡಿ ಮೇಡಮ್ ಅಲ್ಲಿ ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ ರೀ ಸೀರಿಯಲ್ ನಂಬರ್ 1613 ಕೊಡಿ ಸೀರಿಯಲ್ ನಂಬರ್ 33 1613 ಅದು ಕೊಡಿ ಅದು ಕೊಡಿ ನಾಳೆ ಕೊಟ್ಬಿಟ್ಟು ಹೊರಟೋಗೋ ಸುಮ್ಮನೆ ಯಾಕೆ ನೀನು ಫೈಲ್ ಮಾಡ್ಕೊಂತೀನಿ ಅಷ್ಟೇ ನೀವು ಬರಂಗೆ ಇನ್ನು ಕರೀತೀವಿ ಏನು ಮಾಡಿಲ್ಲ ಮಧ್ಯಾಹ್ನ ಕರೀತಾರೆ ಆ ಪಾಸ್ ಅವರಲ್ಲಿ ಫಸ್ಟ್ ಡಿಕ್ಟೇಷನ್ ಆಗಿತ್ತಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 18 ಅಲ್ಲಿ ಅಷ್ಟೇ ಟು ಟೇಕ್ ಸ್ಟೆಪ್ಸ್ ಶಿವನಗೌಡ ಟೇಕ್ಸ್ ನೋಟಿಸ್ ಮೇಡಮ್ ಇದೊಂದು ಫೈಲ್ ಮಾಡಿ 1 ವೀಕ್ ಟು ಟೇಕ್ ಸ್ಟೆಪ್ಸ್ ಅಲ್ಲಿಗೆ ಹೆಂಗೆ ಇಲ್ಲಿ ಡೇಟ್ ಅಪ್ಪ ಎಷ್ಟು ಬರೆಯಂಗಿಲ್ಲ ಮೇಡಮ್ ಮಾಮೂಲಿ ಆರ್ಡರ್ ಇಲ್ಲಿ LKJ ಅಂತ ಬರ್ಬಿಟ್ಟು ಅಂದ್ರೆ ಇಲ್ಲಿ ಸೈನ್ ಮಾಡ್ತಾರೆ ಏನಾಗಿರೋದ್ರಲ್ಲಿ ಅವ್ಳು ಬರ್ತವಳೆ ನೋಡು ಯಾವ್ದ್ರಲ್ಲಿ 1 2 ಆಗಿದೆ ಮೇಡಮ್ ಇದೊಂದು ಫೈಲ್ ಅದು ಯಾವ್ದು ಅದು ಅಮ್ಮ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ನೋಡೋದು ಒಂದು ನಿಮಿಷ ನಾನೇ ಹೇಳ್ತೀನಿ ಅವ್ರ ಮೆಮೊ 20 ಇರಬೇಕು 20 ಹೌದು 20 ಏನ ಅದು ನಂಬರ್ ಏನು MFA ಪ್ರಾಬ್ ಅಂತ ಇದೆ ಪ್ರಾಬ್ ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಇಲ್ಲಿ ಅಲ್ಲ ಯಾರೋ ಫೈನಲ್ ಇಯರಿಂಗ್ ಮಾಡ್ತಾರೆ ಫೈನಲ್ ಇಯರಿಂಗ್ ಅಲ್ಲ ಇಲ್ಲಿದೆ ನೋಡಿ ಸೀರಿಯಲ್ ನಂಬರ್ 31 ಕೊಡಿ 31.1 ಅಲ್ಲಿ ಇರಬೇಕು ಅದು 31.1 ಕರೆಕ್ಟ್ ಮೆಮೊ 31 ಅಂತ ಕೊಡ್ತಾರೆ 31 ಅಡ್ಮಿಷನ್ 230 ಒಂದು ಇಟ್ಕೋ ಆ 18 ಏನ್ ಮಾಡಿದ್ರೆ ಮೇಡಮ್ ಪಾಸ್ ಅವರ ಏನು ಇಲ್ಲ ಅದು ಆಟ ಆಗೋಯ್ತು ಅದು ಒಳಗೆ ಕಳಿಸುತ್ತಾರೆ ಕಳಿಸ್ಬಿಡದೆ ಅವರಿಗೆ ಪಾಸ್ ಅವರ್ ಇಲ್ಲಪ್ಪ ಅದು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ ಅಂತಲ್ಲ ಸೇವ್ ಮಾಡ್ತಾರೆ ಅಷ್ಟೇ 18 ಪಾಸ್ ಅವರ್ ಇಲ್ಲ ನೀವು ಆರ್ಡರ್ ಮಾಡಿ ಅದೇ 1 week fail thanks.
ಹೌದು ಅಲ್ಲ ಮಾಮೂಲಿ ಅದಲ್ಲ ಅದೊಂದು
ನಮ್ಮ ಮೇಡಮ್ ನಿಮ್ ಮೇಡಮ್
ಏನ್ ಮೇಡಮ್ ಏನೇನೋ
Last
Yes,
over is
Mr. Shivanagoda will take that passover first.
NY Srinivasan.
Mm.
There are three connected matter.
Where is he?
Is in the online, Mala.
Yes.
I am appear for the appellants, madam.
Yes, yes.
But
So what are these three different claimants?
please, they were proceeding in a car.
Hmm.
Out of which, Mala, he has filed a one case. The driver is concerned, Mala, 50% negligence was taken, 50-50. In other two, the occupants of the car, Mala, the entire negligence was on the insurance company. Now, for the settlement, sake of settlement, Milad, we discussed each other for the negligence of that person. What has happened, Milad, our insured vehicle was parked on the road. He came and hit from the back. Therefore, Milad, considering the trend of the High Court and the decision of the Exco, 75% of the negligence against the insurance company and 25% against the injured person. In all other aspects, the compensation granted by the court below is on the higher side. So question of enhancement in all cases does not arise. Only to the extent of modification.
What was fixed by the trial court?
Pardon me?
What was the contributory negligence fixed by the trial court?
50%, madam.
So what do you say? Are you okay with that 50%
Please,
and
please. Judicial order can be passed.
No, madam. It's now, madam, modified from 50% to 75%. 75%, madam, is on the insurance company.
75 on them and 25 on you?
Yes, madam.
So like no enhancement?
No enhancement, madam. Other two matters, madam, it may be dismissed, madam.
Another two cases
So
are
that's
there.
what we'll take. Please take the other two matters also.
Tibia fibula fracture and another fracture, madam, 1 lakh is awarded under pain and suffering. Therefore, anyhow company is satisfied. Therefore, no enhancement is.
Yes. So MBC number.
MFA 3798 and 3895, madam. Is no scope, madam.
1 minute. MFA 3832 arises out of?
Is it arising out of MEC 1529 of 2023.
MBC 1529
of 23.
37398.
3798, my lord. 1528, my lord.
1528.
But 3895. 1530.
1530. In
Yes.
which MBC this liability is fastened?
1529.
So 1529 we will modify it to 75%, 25%. 3798, 3895 has to go.
Yes, madam.
Common judgment.
Please.
Yes.
Tribunal has passed a different award, madam.
Oh, different awards are passed. Yes. So then independently I'll dictate order instead of confusion. Agreed with the orders passed in MBC number 1528 of 2023, dated 21st January 2025. Claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 25 lakhs for the injuries sustained by the claimant in the accident. The tribunal, by order impugned, had granted compensation of an amount of rupees 6,67,000 and held that the respondent insurance company is liable to pay the compensation. Learned counsel appearing for the claimant submits that the appellant has sustained multiple facial bone fractures, left iliac bone fracture, 9th and 10th left ribs fracture, and the tribunal has awarded meager compensation under the head of pain and suffering. The appellant the doctor has assessed the disability at 31%, but the court has not considered the disability. the court had taken 16% as income when he was earning 25,000 per month. It is submitted that the compensation needs to be enhanced. Then counsel appearing to the respondent. Your name is there in the list. Then counsel appearing to the insurance company submits that the tribunal, in fact, has granted the compensation on the higher side, and there are no grounds to interfere with the well-considered order passed by the tribunal. It is submitted that under the head of pain and suffering already quoted granted 1,50,000, and for loss of amenities an amount of rupees 2 lakhs is granted, and towards loss of earning also an amount of rupees 32,000 was granted. Next para. And he submits that there is no interferences called for with the well-considered order. Next para. Having got the counsels on either side for the material on record. This court has perused the order passed by the court, and the compensation that is awarded by the tribunal under different heads. The tribunal had already granted an amount of rupees 1,50,000 and the head of pain and suffering, and even under all other heads also the compensation that is granted by the tribunal is a well-considered one, and no interference is called for, accordingly dismissed. Then come to MBC. This is MFA
98.
First matter.
No. 38. Yeah, I am at now. What is dictated is 3798.
Please.
Then come to MFA 3895. Agreed with the orders passed in MAC number 1530 for 2023 dated 21st January 2025. The claimant is before this court seeking enhancement of the compensation. By order impugned, the court had granted compensation of an amount of rupees 8,95,600. The claim petition is filed seeking compensation of an amount of rupees 25 lakhs for the injuries sustained by the claimant. Then counsel appearing for the claimant submits that the court had failed to grant a just and reasonable compensation for the injuries sustained by the claimant, and on all heads there needs to be enhancement. Then counsel appearing for the respondent insurance company submits that already the court has granted somewhere it is echoing. The court had granted compensation, adequate compensation, and in fact the compensation that is awarded is on the highest side, and there is no interference called for. Next, having heard the counsels on either side, there is a material on record. This court has perused the order passed by the court and the injuries that are sustained by the claimant and the compensation that is awarded by the tribunal. Under the head of pain and suffering, court had granted 1 lakh rupees, and for the loss of future earnings, an amount of rupees 3,45,600 is granted, and for loss of amenities, an amount of rupees 50,000, and for future medical expenses also, an amount of rupees 20,000 is granted. Considering from any angle, the order that is passed by the tribunal is a well-considered order, and there is no interference called for, accordingly dismissed. Then MFA 3832. Agreed with orders passed in MBC number 1529 of 2023 dated 21st January 2025. The claimant is before this court seeking enhancement of the compensation and also questioning the contributory negligence that is fixed by the tribunal. The tribunal had awarded compensation of an amount of rupees 4,70,000.
9,41,200.
After deduction?
After deduction, 4,70,600.
Granted compensation of 4,70,600. After deducting, have you calculated what it would be? It is at 75%. No. First of all, what is the entire? No, to say that we have to calculate.
If 75% is taken, my lord, 7,05,900.
It comes to 6,34,000. Then how can it come to 4,70,000, 50%?
50% of 9,41,200, my lord. Total compensation, my lord, 9,41,200. Out of that, 50%, my lord, 4,70,600. Total, my lord, award amount is 9,41,200. Now, my lord, if 75% is taken, the
So
insurance
you'll be
company is
entitled
liable.
to 4,75,000. That's what it shows. 25%. He's entitled for 75% of the amount. Out of 6,34,000, 75 would be the same amount is coming. There is something wrong with the calculation. Look at it.
My lord,
give
one
him.
second. If my lord,
Can you pass out the matter? Any other matter?
Just continue. We'll continue it from there.
List number 3.
Yes. Next one.
List number 3. Serial number 1. Shripadi Shastri.
My lord, in this case, what happened is, my lord, in the first case, actually, may I submit, my lord?
Yes, Mr. Shastri.
R1 and R3 R1 and R3 is the owner of the vehicle. They are not necessary to be implemented. So I will file the memo for dispensation in all the cases. And well, R2 and R4 are the insurance companies. Well, they are satisfied the award, madam.
Yes, sir.
Unmute ಮಾಡಿ sir.
Unmute ಮಾಡಿದೆ.
Unmute
Shripadi
ಮಾಡಿದೆ.
Shastri, sir. You are not audible to the court.
Pass over. I will come back.
ಎಕ್ಸಿಟ್ ಆದ್ರು ಕೋರ್ಟಿಂದ ಎಕ್ಸಿಟ್ ಆಗಿದ್ದಾರೆ.
Mr. Shivanagoda, have you discussed with him? Mr. Shastri, have you discussed with him?
No, what has happened, madam, the pay and recovery order to be passed since the violation. Case for but recovery pass just
Yes,
Malad,
Mr. Shastri.
Malad, now whether I am audible or not.
Sir, your voice is not audible to the court, sir.
I don't know. I actually correct ಆಗಿ ಲಾಗಿನ್ ಆಗಿದ್ದೇನೆ, ಎಲ್ಲ ಮಾಡಿದ್ದೇನೆ, ಚೆಕ್ ಮಾಡಿದೆ. List number 4
can be
enhanced.
Malad, in this case, 458 of 23 is concerned. The injured person was 45 years, 14 multiplier is taken.
It's a case of death?
It's a case of injury. All are case of injury, Malad. 2017 accident, 8,000 is taken, 11,000 has to be taken. 18 multiplier is...
Have you calculated?
No, I have not calculated that amount, Malad.
This will have tomorrow, instead of wasting time on this. Tomorrow.
Please.
Next.
Serial number 2. Serial number 2.
Yes.
Pain recovery order has to pass, my lord. Tribunal has will consider pain recovery.
As
Additional,
not, as considered.
please, my lord.
Yes, seeking enhancement. Let's see, what is the case?
Case of injury, my lord.
Come to the calculation. What are the injuries sustained by him? Yes. Both of you do not have file or what? I'm asking what are the injuries sustained?
You have agreed, ಏನ್ injury? It is agreed for 2,20,000 in
2 lakh?
2,20,000.
Then why are you not saying that?
They want judicial order, my lord.
Why judicial order?
I wanted a judicial order, Your Lordship.
Advocate may not agree for that.
MA City advocate.
Let it be, file a joint memo.
Please.
The insurance company, land counsel appearing for the insurance company submits that. Insurance company is ready to pay an amount of rupees 2,20,000 again in addition.
Please, Your
In
addition to
what has
3,04,000.
What has been awarded by the tribunal. It's along with interest.
Please, Your Lordship.
No, my lord, globally 2,20,000 rupees.
Globally.
Yes, Mr. Shivanagoda, is it so?
Please.
Globally, the insurance company is ready to pay an amount of rupees 2,20,000 in addition to what has been paid by what has been awarded by the tribunal, and both the parties will file a joint memo before the Lok Adalat. List this matter on Thursday. Next.
This case I feel for the appellant, my lord.
What about this?
Second respondent is concerned. I will file a memo for seeking dispensation of notice, my lord. It is a case of injuries, my lord.
Happening. Yes, what about this?
Case of injury, my lord.
Injuries,
No.
my lord.
My lordship may
Any
be,
discussions are over in this?
no, my lord, we not settled. My lordship may be order passed.
In this case, it is a case of injuries, my lord. The claimant was 47 years old person and accident is of the year 2014. The nature of injuries sustained by him are right hip joint dislocation, right femoral head fracture, right actabulum fracture, right sciatic nerve injury, contusion over front of the neck. 4 grievous injuries, 1 simple injury. And the tribunal has awarded 5,11,000. 5,11,389. So, your lordship may kindly see the doctor has deposed that he has sustained 23% whole body disability. Am I audible, my lord? Am I audible, my lord?
Yes.
Then,
Please
so he
come
was
to
a
the table. Please come to the table.
Table, page number, running page number 42, your lordship may kindly.
40?
42.
Yes.
Para 31, pain and suffering 50,000 has been awarded.
1 minute. What are the injuries sustained?
That is fracture of.
How many fractures?
4 fractures. 4 fractures and 1 simple injury. And he has undergone 2 surgeries. And implants were inserted. 26 days he was hospitalized.
1 minute. Yes, Mr. Under the pain and suffering.
Pain and suffering,
He has got 4 fractures.
50,000
2
awarded, my
operations.
lord. 50,000
It
awarded.
is awarded. We'll award another 50.
I will brief one more part. We prepared appeal.
We have
Challenging this order. Thereafter, my lord, we have withdrawn that appeal.
Oh.
We have withdrawn the appeal. After withdrawal, they have filed the
file claim.
I'm
That
giving
I
some
have no
picture
idea.
in-
I did not receive any notice.
Another
50,000 it is granted, my lord. That is, I think it is just and reasonable.
He has got each fraction we're granting 40,000. Additional another 20.
15.
40 plus 20, 20. Oh, total 4. How much it becomes? 40 plus
20 your
60.
lordship taken.
So we'll grant 80,000 towards pain and suffering. Then food nourishment. How many days was in hospital?
26 days, my lord.
Oh, that is reasonable. 30,000 is reasonable.
But amenities also, no, in that ground, amenities are also included. That is not correct.
What is towards food, nourishment, conveyance, attendance,
And
loss
also
of amenities we can grant under a different head. Then loss of income during later period, how many days? You said he was in hospital for 26.
26
Two
days, he has
operations.
undergone 2 surgeries.
Which
Up
year
to
is the? Yes, yes.
2015 accident.
What is
2014
the-
accident.
what is the
8/9
amount?
2014. 8/9 2014 accident.
8,500 and 23 to future prospects have not been granted, my lord. Because more than 23% whole body disability, he is walking with crutches. He is not in a position to walk independently also. And
No,
he is
first of
doctor
all,
evidence is he is not
loss
able
of
to do.
1 minute, I'll ask you whenever required. Loss of income during the later period. What in 2014 it is 8,000?
8,500.
Where is that?
8,500.
Chapter?
8,500, my lord.
8,500.
Yes.
Then it should have been at least for 4 months.
4 months, 2 surgeries.
8,500 into 4. It comes to 34,000.
34,000.
Then future loss of income. What do you say? The future prospects need to be taken or not?
The future loss of income may not be
Because
because 23%.
whole body disability. Not limb disability. Whole body disability of 23%.
Correct, Milad. 20 to 23, it is not much different.
From where we are concerning
so
for 30.
it can be granted the compensation or the amenity.
Yes.
So it's
So,
not future loss.
so if we take this 8,500 into 12, what is the age? What is the multiplier?
45 years age.
47, my lord. 13 multiplier.
13 multiplier.
13 into disabilities, 28 or
23%.
23 by 100.
And future prospects, your lordship may kindly see. There is a division bench judgment of this honorable court. So if it is 20%, future prospects should be added.
47.
We will grant the amount in amenities. Now it comes to 3,04,980 medical expenses. Then amenities.
Amenities, nothing is granted, my lord.
550. Amenities 50.
Yes, ma'am. And future treatment also, he has got the implants are there.
Implants have to be removed.
Yes, my lord.
Amenities. Future operation 20,000.
2010, Milad, 15 accident.
10 years after completed.
Now again that story of producing the slips and all will not go.
Allah. See, from 2014 till this day, they have not undergone operation. If they have undergone operation, they would have produced.
That's what I'm saying. That's what the usual defense of insurance company.
Yes, yes.
It comes to 5 lakh. Why there is no difference in the? Oh, this one is plus 1,25,509. It comes to 6,44,489.
Even
It's
later
coming to
period, my lord, total amount, medical expenses also has to be included.
Everything is added.
Yes, yes. And future treatment 20,000.
That is also added. Amenities 50,000 is added.
1,25,509 medical expenses and
Yes.
pain and
With
suffering
that,
80,000.
it's coming to 6,44,000.
Very meager investment because 4 injuries.
No,
Yes,
let's see again, or it's some mistake in the calculation.
yes, yes, I will also see. Loss of amenities, how much, Mela? 50,000.
Same amount. It's coming to 6,44,489.
Even incidental charges 30,000 has to be retained.
What incidental charges?
That is conveyance, attendant.
That is also there. 80,000
awarded, ma'am.
80,000 pain and suffering, Food and nourishment, 30,000. Loss of income during laid-up period, 34,000. Future loss of income, 3,04,980. Medical expenses, 1,25,509.
Yes.
Loss of amenities, 50,000. Future operation, 20,000. Coming to 6,44,489. Yes. The learned counsel appearing for both the parties submits that the insurance company is ready to pay an amount of rupees 6,44,489 against the awarded compensation of 5,11,389 along with interest. List this matter before the Lok Adalat for filing the joint memo on Thursday.
Serial number 4.
Please.
Loss of government.
Yes.
Global compensation of 69,000 is granted.
69,000. Here he has a crush of his middle finger, right finger, ring finger. I have produced the records also.
No.
Yes.
Is there any?
No doctor was examined.
No. Like, have you any negotiations on this?
They have negotiated, but
20,000 rupees.
20,000, but a whole bill of exhibit is not taken into.
Then we'll hear it in a regular course. Let's delete this matter
Date may be given.
and list the matter. It's MFF 2023. List the matter on 15th of September. Yes, next.
Serial number 5.
Yes.
Vijay Kumar.
Your lordship can increase some more amount and close the matter
My
because
lord.
no evidence was secured.
No, but if we have to close, they should agree.
We have produced the documents. The court has not considered exhibit P14, which is itself 70,000 rupees.
How much can be increased according to you?
But, we have offered 25,000.
Above what has been granted?
Another 15,000 rupees can be granted because CC.
Exhibit P14. No, it has been produced. The court has also stated.
We'll hear it when you have a case on merits. Yes, next 5.
Yeah.
5. C. Vijay
My
Kumar.
lordship, in this, kindly see, my lordship, the proposed respondent, I had it in that. On the day of accident, the vehicle is covered under the insurance. In the trial court, they have not produced the document. For that reason, the proposed respondent number not yet made a party in the trial court. Kindly see, my lord.
What is that? Insurance company is exonerated from the liability.
No policy.
Where is that IA?
Yes, my lord.
IA number?
IA number, I don't. Policy, I filed. Kindly see page number 30, my lord. Page number 30. That policy in that insured code name is Ansuya. This is the respondent number 1. In this, he is the petitioner. That period of insurance
Where
coverage.
is that application filed by you
24/12/2014.
under Order 1 Rule 10? Where is that application filed by you?
That application filed on what
Yeah.
date, ma'am is asking.
That amount also deposited in the trial court 50%.
Sir, we should where your application. Policy and additional evidence.
What application?
Part of the paper only there.
We'll see. The Liz matter.
Kindly be give it 2 weeks time. I produce the document also, my
This
lord.
matter on 28th of July. Yes, next.
Serial number 6.
What about this, Mr.
Bana Prakash HV.
Where is Mr. Ban Prakash? 1 lakh?
Memo for, I call for LCR, my lordship.
Yeah.
Memo
Not
for
interested for
dispensation.
settlement? You are not interested for settlement?
No, LCR is necessary, my lordship. His last is eyesight, that's why. R1 dispensation.
You take notice for the respondent? Mr. Shivanagowda, take notice for the respondent?
Please.
Then counsel, Mr. Shivanagowda is directed to take notice on behalf of the insurance company. Then the petitioner shall furnish this is a memo for dispensation to respondent number 1. A memo is filed seeking dispensation or notice to respondent number 1. The same is taken on record and dispensed with. As far as respondent number 2 is concerned, the petitioner shall do the needful within a period of 1 week. Yes, call for the DCR. Yes, next.
Serial number 7.
7 maybe tomorrow, my lordship.
Tomorrow.
Please, my lord.
Memo is filed seeking dispensation of notice to R1. Same is taken on record and notice is dispensed with. This is matter tomorrow.
Please, my
In the same list, third list.
Cell number 8. Jagdish Shetty.
You're for the respondent.
For the respondent.
The petitioner shall do the needful within a week. Default order. Next 9.
Cell number 9.
For the appellant, my lord, I already filed a memo for dispensation of R1, my lord.
What about Anup Sitaram Rao is appearing in this? Same Shriram General Insurance? Any scope for settlement?
Please. Dispensation for R1.
Any other matter will be taken, my lord.
Next matter will be taken.
Yes. Call this matter after a while. Next.
Cell number 10. Cell number 10. Vijay Kumar. Vijay Krishna Bhattam.
What about this 10?
We are ready to settle the matter.
Where are they? Let's this matter tomorrow. No representation for the appellant. Next.
Cell number 11.
Where is Mr. Ballare?
We have filed a review before the MACT
Oh.
regarding age factors.
The office objection.
Also agreed, but they will settle the matter before MACT. Therefore, till that day it is.
The appellant shall do the needful within a week. Shall comply with the office objections within a week. Default order.
Cell number 12. Chandrasekhar Iyer B.
In 12, memo is filed seeking dispensation of notice to R2, same order. Next.
2 vehicle is involved, my lord. KSRTC and also insurance company.
I number, what do you say, Mr. Shivanagoda, on the delay? Condition on condition. I number 1024 is filed to condone the delay of 935 days in filing. Same for the reason stated, delay is condoned on the condition that they will not be entitled for interest in the event of their. Yes, next. Who is KSRTC? Mr. Dabali appears for the KSRTC.
Dabali is there.
Dabali is directed to take notice on behalf of the R1 KSRTC. Print the name of Mr. Dabali. Yes, next.
13.
Appearing for the appellant, my lord. This matter will not settle before the Lok Adalat, my lord. The records may be called, my lord.
Yes. Oh. Yes, Mr. Shivanagoda, will you take notice for same? Mr. Shivanagoda is directed to take notice on behalf of respondent number 2 and the council. Respondent number 1 or 2, 1 is already dispensed with. For respondent number 2, and the council for the appellant shall serve the copy of the appeal memo on the council. Next, IA number 1 of 25 is filed.
We are ready.
They are not ready. IA 1 of 25 is filed to condone the delay of 227 days in filing, condoned on condition, admit, call for the TCR. Yes, next.
Cell number 14.
Matter maybe tomorrow.
Tomorrow. Yes, tomorrow in the third list. 15.
Cell number 15.
My lords, for appellant, my lords, condonation of delay of 237 days, my lords.
Ready.
What is it? What is the offer from the company? What is it?
No, he has not come forward.
He has not come forward. IA number 1 of.
If he is ready, my lord, we will dispose of the matter.
Yes, Mr. Counsel, are you ready for any settlement?
My lords, it may be referred to mediation, my lords. I will take a chance, my lords.
Come to the court. Court will mediate.
Yes, my lords. Yes, my lords.
PC. Maybe directed
Print the name of Mr. B.C. Sivanagoda. Is directed to take notice on behalf of the insurance company. Next 16.
Cell number 16.
Girimalaya is out of station, my lord. Kindly have this matter.
Are you ready? Any calculation is made? How much?
No.
He's coming tomorrow.
Not tomorrow, my lord. Next week. Any date.
IA number 1 of 25 is filed to condone the delay of 36 days. Condoned, admit, post for final hearing, call for the TCR. Next.
Number 17 for admission matter. 17. Nataraj.
Where is Mr. Nataraj?
Anup Sitram Rao.
Responding to.
Admit, post for final hearing.
Cell number 18. Cell number 18.
Vehicle damage, my lord.
Vasant
Vehicle
Appa.
damage.
Vehicle damage.
No, it was discussed we have given some offer, but company says that it is on the AIR side. We have given 70,000 rupees an offer.
75,000.
75, yeah, maybe.
75.
Company was not
Madam.
agreed.
It is acceptable to you? Then I'll pass a judicial order.
That's what.
Oh. Give that. Please come. Agreed with orders passed on MSC number 3750 of 2018 dated 3rd October 2019. The claimant is before this court. Agreed with the order of the tribunal, whereby the tribunal had granted an amount of rupees 1,25,000 towards compensation for the damage of the vehicle, and held that the insurance company is liable to pay the amount. It's a case of the claimant that he has spent an amount of rupees 3,25,000 towards the repair charges and rupees 50,000 towards the loss of usage of the vehicle. The tribunal had granted 1,25,000, and while granting the said amount, the tribunal has observed that
At para 14.
the insured declared the value for the vehicle as rupees 2,51,711, and as per exhibit P6, the cost of the repair charge by including labor charge and VAT is rupees 2,41,004. And the petitioner himself has stated that vehicle is not in a repairable condition. On going through evidence of PW1 and PW2, it is clear that the vehicle belonged to the petitioner and is not yet repaired. And admittedly, engine is not dismantled. And PW2 admitted that in the report of the motor vehicle inspector, it is specifically stated that the brake system of the vehicle is intact. And hence, without any further discussion, the court had granted an amount of rupees 1,25,000. Then counsel appearing for the petitioner, appearing for the appellant, submits that the court ought to have granted an amount of 2,41,004 along with labor and GST charges. And the interest should have been more than 6%. The court has failed to consider the total repair charges and labor charges. And it is submitted that the order, the appellant is entitled for enhancement of the compensation. The learned counsel appearing for the insurance company submits that the court, basing on the evidence, had rightly granted the compensation. And there are no grounds to interfere with a well-considered order passed by the tribunal. Having heard the counsels on either side, this court has perused the order and the material on record and the other material on record. No. What are the documents that are placed before the court? Where is Mr. Shivanagoda? Why you have offered 75,000? Your company was right. Where is the material?
They have not produced the document, my lord. Somehow my colleague has discussed that matter. So,
no, my lord.
Where are the documents?
I have examined the
Examination
surveyor.
is not sufficient.
Surveyor, vehicle surveyor. He himself admitted that the cost of repair is to the extent of 2,41,000, and IDV value is 2,51,000.
I'm not inclined to pass an order on this.
Please.
Mrs. Matter, admit post of final hearing.
Case number 19. Spurti Hegde for appellant. Pradeep.
Appellant, my
I am
lord.
for respondent, my lord.
My lord, tribunal has not awarded any amount towards loss of future earnings, my lord, stating that, my lord, after the accident, also he continues doing the work. On that ground, my lord, tribunal has not awarded.
Let's see the table, come to the
Please,
table.
my lord.
Judgment page number 13, my lord. In
No
PW
table?
1 is a cross examination is admitted, my lord.
Table.
Madam, page number.
No table, I think.
Not
What was
open.
granted is 4,48,094.
But 3,33,000 is the medical bills, my lord.
1 minute. Where are at least subheadings?
Subheadings is not given.
What is this judgment? So let's say, how many are the injuries?
3 fractures, my lord.
Is it correct?
Please, my lord.
So we'll grant.
That is page number 11.
We'll grant 60,000 towards pain and suffering. Then.
Lord, he was admitted to the hospital for 10 days and he underwent surgery.
Which year is the accident?
2016.
2016. What is the amount?
9,500.
So 9,500 into 3.
My lord, sorry, my lord, 2019. 2019 accident.
2019 is 14,000. Comes to 42,000. Then loss of amenities. What is the disability?
Disability, my lord, doctor has assessed a total 89%, my lord.
To the limb.
Please, my lord. There are 3 fractures, my lord. To upper limb, my lord, 38% is assessed. To lower limb, 51%.
What was the job you were doing?
My lord, he was agriculturist and doing real estate, my lord.
In cross examination, he has admitted, my lord. After accidents, also I am doing same agricultural and real estate business.
So it will not have any impact.
He clearly stated after accident he could not do agricultural work, so he continues in the real estate.
So his whole body disability will come to 29.6.
Please, my lord.
So let's say 29.
Please, my lord.
So the salary is 14,000.
Please, my lord.
Into 12.
Please.
Into what is the age?
37.
What is
37 means 15, my lord.
Please, my 15 applicable multiplier.
15 multiplier.
15 into 26. It comes to 6,55,200. Then what are the other heads? Loss of amenities.
Please, my lord.
Loss of amenities with that disability will grant him 50,000. Then
towards laid up period, my lord.
Nourishment, transport. How many days were you in the hospital?
10 days.
Then we'll grant 15,000 under that. Medicals?
Medical as it is, my lord.
How much?
3,33,094.
3,33,094.
33,090 rupees.
094.
My lord, towards laid up period, my lord.
I granted already.
Please, ma'am.
Loss of income during laid up period 42,000.
Please.
So with the 6,55,000 plus 60,000. it comes to 11,55,294.
Judicial order.
My lord, judicial order, my lord.
Agreed with the order passed in. MVC number 325/2020 dated 18 July 2022. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 21,50,000 for the injuries sustained by the claimant in the accident. The tribunal has awarded an amount of rupees 4,48,094. It is evidence of the doctor that the claimant had sustained 89% disability to the whole body, and the claimant is doing agriculture as well as real estate. The court has not considered the future loss of earning on the ground that the petitioner, even after the accident, is continuing to do the agriculture and other real estate business. The real estate business. When it comes to the pain and suffering, the court had awarded an amount of rupees 50,000, and 15,000 is awarded towards loss of income during the later period. A sum of rupees 25,000 is awarded towards loss of amenities and future unhappiness, and an amount of rupees 25,000 is awarded towards right and the other charges. No, it is 25,000. 25,000. Then another 10,000 will 1165. 25,000 is awarded towards right and other charges, and towards medical expenses, an amount of rupees 3,33,094 is awarded. Altogether, a compensation of 4,48,094 is awarded. Next parallel, counsel appearing for the petition submits that the tribunal had not awarded a reasonable compensation for the injuries sustained by the claimant. When the petitioner had sustained whole body disability of 26%, the court was not right in not granting the loss of future earning. It is submitted that on all the counts, the compensation that was awarded is not just and reasonable. When counsel submits that the income should have been taken as 14,000. How much the court had taken?
Court has not awarded.
No, because it is 1 month so that means that's the court ought to have taken
2 months, my lord.
The court ought to have taken 14,000 as the income at this an accident of 2019. He submits that on all counts the compensation needs to be enhanced. Then counsel appearing for the insurance company submits that court has rightly considered his own admission that he was working even after the accident, and as it has no impact on his future income, court has rightly not considered the future loss of income, and on other counts the amount that is granted by the tribunal is just and reasonable. Next para. Having heard the counsels on either side, peruse the material on record. Considering the 3 fractures that are suffered by the claimant, this court is granting 60,000. Coming to the loss of income during the later period, as there is no evidence on record to show what is the income, as per the chart prepared by the Legal Services Authority, as this accident has taken place in the year 2019, this court is taking 14,000 as income into 12 into 15, and considering 89% whole body limb disability, this court is taking the whole body disability at 26%. Then the loss of income, loss of future income will come to 6,55,200. Nourishment, court below had granted 25,000, and this court has not inclined to interfere with the same. The court had granted medical expenses at 3,33,094. That is, and as per the evidence, no interference is called for. Then towards the loss of amenities, considering the disability of the 29%, this court 26%. This court is granting an amount of rupees 50,000. Altogether, the claimant is entitled for an amount of rupees 11,65,294. Accordingly, the appeal of the claimant is allowed, enhancing the compensation from 4,48,094 to 11,65,294. Yes.
Cell number 20.
Paying for the appellant, my lord.
Kumar.
My lord, in the appellant connected matter, my lord, I prefer the appellant.
Hmm.
20.
In
Yes.
the records request to be called for in a first matter, my lord.
Admit post for final hearing. Call for the TCR. Next.
Please.
Cell number 21.
Yes, next.
21.
What about this 21?
Jagdish HT.
Please,
O
madam.
Mahesh.
963.
No, no. 2752.
2752.
Jagdish is ready, madam, ready.
O Mahesh sir.
Tomorrow?
Omesh, I will assist Omesh.
Tomorrow?
Please.
Where is Mr. Jagdish? Not online also. Tomorrow? No representation for the appellant. Next 22.
Serial number 22.
22, two vehicle is involved, madam. Served, but
Admit post
no
for final
representation.
hearing. TCR.
Serial number 23.
Served, no representation, madam.
Yes.
23.
23.
Sushmita G for appellant.
No representation for tomorrow. Next 24.
Serial number 24. 24.
Yes, 23. Sushmita.
Please. 963.
Sushmita.
Yes.
The amputation of left.
How much you are ready? Calculated.
38% she has to give. She has to.
She has to.
She never approached for settlement.
Any scope for settlement?
Let us argue the matter for a minute. Only quantum. Let's see.
Yes, madam.
38% the whole body disability.
Let's see. Where is the table? Previous case, I keep, no?
Table is in 37.
In the previous case, in the file.
(2014) accident, my lord.
Yes, my lord.
Just now I made this calculation. Just now I made it in the other matter. Yes. Where page number?
Page number 37 is the table, my lord. Para number 37.
So, how many are the injuries, Sushmita?
My lord, amputation of left lower limb above knee, my lord.
Amputation of left lower limb.
Then at least 1 lakh we should give towards pain and suffering. And then?
Towards loss of future in earnings, my lord. The court has taken the 8,500 has to be taken income.
Which year is this accident?
14.
8,500.
38% of
What is the disability according to the doctor?
38% to the whole.
To the whole body.
My lord, he was agriculturist, my lord. So functional disability, he was agriculturist by profession, my lord. So functional disability will be 100%, my lord.
Why not?
Pardon?
The whole body disability. Now, agriculture, we have to consider it as 100% disability. He cannot work.
My lord, he is aged about 66 years.
60?
6 years. Not an young boy.
Yes. 66 years is the age. What is the future prospects now? We will not consider the future prospects. So, 8,500 into 12 into what is the multiplier? 5 or 6?
5.
5 into 30?
8%. That 93,800.
38 divided by 100. It comes to 1,93,800.
800.
How much was granted? Same. Then towards medical expenses. Any dispute on this?
No. Towards future amenities concerned, let some amount.
42,490. Food nourishment. Where is she?
It is granted.
She left. 71,000. Loss of amenities will increase it.
Lakh.
One.
Please.
1 lakh. Now, we'll post this matter tomorrow. She is for orders, for judgment tomorrow. She's not visible. It comes to 5,07,296. Oh, one of the 6 lakhs,
6.
7,296. Due to technical slang, then comes to the appellant is not audible. List this matter tomorrow for judgment in list number 3. Next.
Cell number 24, Tantraj K.
And for respondent, my lord. Case of injury, my lord.
Where is Mr. Nagaraja?
Shantraj.
Raj.
Case Shantraj. P for serial number.
Oh, the last one. Where is he? Admit post for final hearing.
Tomorrow,
Call
my
for the
lordship.
TCR.
Tomorrow.
He'll not come. Call for the TCR. Next.
Cell number final hearing, cell number 25.
Appearing for the appellant, my lord. Contributory negligence is there, my lord. Tribunal taken.
Have you spoke? Yes, Miss. Oh, this is Krishna Swami appearing. This matter 25.
Contributory negligence is there, my lord. 25% taken the tribunal, my lord.
That also can be, you can negotiate. Tomorrow. Yes. 26.
Cell number 26.
Same in all these matters will come in third list tomorrow. Whatever adjourned from.
And for respondent, connected matter claim, insurance company also filed one more appeal, my lord. 676 up to 2021.
Take that list along, post along with
676 up 21.
So and so these matters on, you are on the liability.
Contributory negligence, 2 vehicle has involved.
Then list this matter on 12th of August.
Please, my lord.
Yes, next 27.
My lord, 2 weeks time may be granted. I don't have copies to submit before the court, my lord.
10 times he has taken.
10 times?
Adjournment was taken.
No, my lord, you only not filed the wakalat. For that it was adjourned, my lord. 2-3 times it was adjourned, my lord.
The argument on merit.
Last on 30th June, I have taken 2 weeks time. That's all, my lord.
August.
It may be go through.
28.
Yes, next 28.
Cell number 28.
This also. This is a matter on 9th of September. Next 29.
Cell number 29.
I am for insurance company challenging on the ground of quantum, my lord. Case of death, my lord. Instead of 50%, 1/3 has been deducted. That is the only one ground, my lord.
Where is Mr. Sridhara?
Sridhara K.
This matter for judgment tomorrow.
Yes, ma'am.
In the same list. We'll see tomorrow. Tomorrow we'll dispose it off.
Please, my lord.
Yes,
Cell number
next.
30. Ravishankar Shastri Ji.
For respondent for my lord.
Where is Mr. Ravishankar Shastri?
Anup Sitaram.
Anup Sita.
List the matter. These are all for final hearing.
Yes.
List this matter on 15th of September. Yes, 31.
15,000.
This also 15th of, 15th of September.
15.
Then 32.
32.
32. Company appeal is there, my lord. Matter may be tomorrow, my lord. Connected matter 5209 up.
Submitted that the company appeal is there. Give that number.
Please, my lord.
Post along with that on September 23rd.
Cell
Next.
number 33. K. Prasanna Shetty. P. C. Shivanegowda.
Seeking for time, my lords.
Any scope for settlement? No, sir. Post this matter on 8th of October. Next, 34.
Cell number 34.
Please.
Case of injury.
Yes, miss. You're. Take that.
Date of accident occurred on 23/2/2022.
Where is the table? Come to the table straight away.
Ink page 27, madam.
27.
Yes.
Hmm.
Doctor assessed.
What are the injuries?
Shaft of right femur. Shaft of right femur.
Ink page 21, madam.
Only one.
Comminuted fracture of shaft of right femur.
Hmm.
And simple head injury with with cut lacerated wound over the chin and soft tissue injury of right hand. And he followed tailoring work.
Oh, pain and agony.
Pain and agony, 75,000 is granted.
She was a tailoring.
It's also there. Head injury is also there. Another 25. Then medical expenses as it is.
13 days hospital.
How many days?
13 days. 25,000 is granted.
13, 13.
13.
25,000 is a reasonable amount.
Doctor assessed 50,000 for future medical expenses.
We'll go. You look at your table, one by one we are going. Future medical expenses. 30,000 is also reasonable.
Granted.
Then loss of income during laid up period. How many days was in hospital? You said
13 days.
13 days.
Then
3 months.
how many months the court has granted?
4 months.
4 months.
Then that also do not require any announcement. Then come to the next head. Then loss of future income.
Loss of future income 69% limb disability and 23% whole body. She is a tailoring work.
1 minute.
A femur fracture.
Loss of income during laid up period. What is, according to the doctor, what is a whole body disability?
23% to the whole body.
And 66% to the
limb.
Not taking a future prospects. She is a tailoring work.
53%.
Femur fracture.
But with the femur injury and this disability and for her profession, future prospects has to be considered. What is the income?
15,500. 15,500 is considered.
No, 22 accident.
Which year is the accident?
2022, Malad.
22 is 15,500.
Yes,
It should be 40%. What's her age?
26 years.
So far as head injury is concerned, no doctor was examined. Orthopedic surgeon is examined. That itself says that it's not a serious.
This future prospects we are considering basing on that femur injury and it would come to 21,700 into 12. What is the multiplier?
17.
17.
Into
25%. 23%.
It's coming to 10 lakhs 18,164. Then this loss of amenities. What do you say?
35,000 is
Granted, future prospects is
Huh?
granted for a simple.
What is that?
50,000.
Another 10,000 may be granted on that.
We'll make it around 50,000.
Yes, 15.
So, it's coming to 13 lakhs 81,714. Yes, Mr. Shivanagoda. Joint memo.
Because future prospect is there. Therefore,
Agreed with the order passed in. MVC number. This is 479 or?
479. Another case disposed in Lok Adalat already.
Agreed with the award passed in MVC number 479 of 2022, dated 14 September 2023. Whereby the court had granted compensation of an amount of rupees 10,50,810. The claimant is before this court. The claim petition is filed seeking compensation of 20 lakhs for the injuries sustained by the claimant in the accident. It's a case of the claimant that she's seeking her livelihood by doing the tailoring work. And as per the evidence of the doctor, there is a femur injury, fracture to the femur, and the disability as per the doctor is 66% to the limb. Court had taken 23% as a disability to the whole body. And considering how much was considered as salary?
Sir, 15,500.
Considering 15,500, court had granted an amount of rupees 7,27,260. And when it comes to the pain and suffering, an amount of rupees 75,000 was granted. And towards loss of amenities, an amount of rupees 35,000 is granted. Land counsel appearing for the petitioner, appellant claimant submits that. Considering the head injury and the femur fracture, the court has not granted the amounts and the head of pain and suffering. He submits that she is a tailor and a femur fracture and a disability of 23%. The court ought to have taken the future prospects into consideration. That aspect was not considered by the court. He submits that on all the counts that the compensation that was awarded was not a just and reasonable compensation. Then counsel appearing for the insurance company submits that the court had granted a reasonable compensation. No evidence is adduced with regard to the head injury, and no interference is called for with a well-considered order passed by the tribunal. Next para. Having heard the counsels on either side, peruse the material on record. This court has perused the order wherein the injuries that are sustained by the claimant are a fracture injury to the femur and also a head injury. Hence, under the head of pain and suffering, this court is granting an amount of rupees 1 lakh. Coming to the medical expenses, basing on the evidence, court has rightly granted and no interference is called for. Even under the future medical expenses, food, diet, and conveyance, court had granted reasonable and also loss of income during the later period. Court has granted a reasonable amount and no interference is called for. Coming to the loss of future earning is concerned, considering the disability of 23% and the claimant is a tailor profession, and that the femur fracture and the disability would have an impact on a future earning. Considering the age of 26, this court is inclined to grant the future prospects. So 15,500 and the future prospect at 40% will come to 6,200. And the income is 21,700 into 12 into 17 into 23 by 100 is 10,18,164. Coming to the loss of amenities, considering the injury, this court is granting an amount of rupees 50,000. Altogether, the claimant is entitled for an amount of rupees 13,81,714. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 10,50,810 to 13,81,714. Now, all these orders, they have a format in the that you take and do accordingly. Yes, next.
Serial number 35.
Yes.
Guru Prasad BR.
Where is Mr. Guru Prasad?
Yes.
Case of death. Then we can do it.
Yeah, but
This is matter tomorrow. No representation. Inform him.
Passover to matter, sir.
One Passover is there. What happened to that?
My lord, I say serial number 1, my lord.
Your matter is tomorrow because you were not audible.
I don't know what happened when we console. There is several problems nowadays appearing.
Anyhow, tomorrow you can connect.
At list number 2, serial number 43, Passover.
First matter.
by email there is some calculation.
Take out that, no? First one. Till where I've dictated. Ah, 4,70,600. What is the amount?
Kindly see, my lord, my synopsis, my lord. The amount is 9 lakh, my lord, 41,200.
Let me look at this now.
9,41,200 total amount, my lord.
Compensation is 9,41,200. In
25%
that quote,
of
as 50% contributory negligence is fixed on the claimant, the court had awarded compensation of an amount of rupees 4,70,600. So now, out of this 9,41,000,
Please.
25% is
41,200.
Half of the amount I am liable to pay, 4,70,000 off.
No, 25% is his. So he's entitled for 75% of the amount.
Yes, my lord. 2,35,300 is my part, my lord. Appellant
So he's
25%.
entitled for 7,05,900.
900.
What? Just read para before. What was dictated? Hmm. 70,000. Learned counsel appearing for the appellant submits that the court had, without any basis, had fixed the contributory negligence at 50% on the claimant and 50% on the respondent. It is submitted that the court has failed to look at the documents that are produced by the the appellant claimant. Which paragraph, Mr. Sriniwas?
Para 12, my lord.
With regard to this contributory negligence?
Para 12, my lord. Para 12 of the judgment.
Issue number 1, my lord.
It is submitted that the court has observed that the accident has occurred due to the equal negligence of the claimant as well as the driver of the offending vehicle. It is submitted that there is no such material before the court.
Para 12 of the judgment.
That's what I'm looking at. There is no such material before the court to come to such conclusion that there is 50% contributory negligence on the part of the claimant. It is submitted that even the amount of compensation that is awarded by the tribunal needs to be enhanced. Land counsel appearing for the respondent insurance company submits that the tribunal had rightly considered and held that there is 50% negligence on behalf of the claimant as well as the respondent. And respondent, he submits that the compensation that was awarded by the tribunal is already on the higher side and there is no interference called for and no enhancement is required in this case. Next para. Having heard the counsels on either side, peruse the material on record. As per the it is a case of the insurance company that the accident did not occur due to the sole negligence of the driver of the offending vehicle, but the same due to the contributory negligence of the claimant who hit the parked lorry from the hinge side. The insurance company had examined the branch manager. At what time the incident has happened?
Evening.
Night, in evening?
Evening.
What's the time?
I will.
1:30 a.m.
1:30 midnight, my lord. 1:30 a.m. my lord.
Dark.
If it has to be heard on the merits, no contributory negligence at all.
No, my lord, the award amount in all the cases on the higher side, my pain and suffering 1 and 1 lakh it's granted.
What is that? It examined the branch manager who reports that the accident occurred due to the rashness and negligence of the petitioner of the claimant by hitting the parked lorry from the hinge side. And basing on this, the court had fixed the contributory negligence at 50% on both the claimant as well as the respondent. This court has perused the evidence and other material. The accident had taken place at 1:30 a.m. and and it was parked on the road. Admittedly, there were no the parking lights were not on. In those circumstances, this court is of the view that fixing the contributory negligence on the claimant at 50% is on the higher side. Hence, the same is apportioned as 25% on the claimant and 75% on the respondent. Then coming to the contribution, on all the heads, the contribution that is awarded by the tribunal is as a reasonable compensation, and this court do not find any reasons to enhance the compensation. Accordingly, the appeal of the claimant is partly allowed, whereby the contributory negligence is apportioned at 25% on the claimant and 75% on the respondent.
Yes, number 3, serial number 9, pass over. Raju, yes. Yes, sir.
Which one? Yes. What about this?
Blood, we have given the offer 70,000.
Raju
Raju has to agree.
He is not accepting.
He will agree, my lord.
Why? Joint memo you will file on him on his behalf also. Yes.
1.5 lakh. I'm offering 1.5 lakh, my lord.
You are offering.
Yeah, please, my lord.
What injury, sir?
23% disability, my lord. Future prospect is not added. Serious injury, no. 3.
So you are, how much is a insurance?
We have offered
75,000 you have offered.
70,000.
Earlier occasion is earlier
let
occasion,
the
my
court
lord,
can
is offering
decide up to
80,000.
Let's see.
80,000 plus interest.
Let the court can
See
decide.
how much it comes, then accordingly they will, amount has to be increased, then they will increase. And I come to that table. Page number?
Page 32.
Where is that table?
Para 49, 23% disability.
How many, what are the injuries?
Injuries, my lord. Ink page 24, my lord. Ink page 24, sorry. Para 33.
No fracture.
Multiple abrasions of the right thigh and abrasion of the frontal region. A cut lacerated wound over the right eyebrow. Where is the fracture?
And right side, my lord. Pain and stiffness of the right ankle. Right leg shortening of present. And arthritics of right ankle.
So how much is granted towards pain and suffering?
Pain and only 40,000, my lord.
40,000 is sufficient. What is wrong in it? Then?
Then
how many days was in hospital?
Hospital, my lord.
4 days.
No.
25,000 for this injuries, it's fine. Then loss of amenities. What is a disability?
Disability 23%.
To the limb.
Whole body 23%.
No fractures
According to the PW2, limb 69%, 1/3 is taken, 23% whole body.
No, what are the injuries? What is a disability? You have not sustained any fracture injury.
Cut and lacerated wound over the right leg exposed.
Multiple abrasions over the right thigh.
Please.
With that, what is this disability? With this, what is the connection between the injuries and the disability?
According to PW2, I'm not an expert.
Better take 75,000. The counsel for the respondent submits that they're ready to pay an amount of rupees, globally an amount of rupees 75,000.
70,000, 79,000 plus interest.
75,000 in addition to what has been granted by the tribunal, along with interest. List this matter on Thursday for filing joint memo. For filing joint memo.
With interest, my lord.
I said with interest. Yes, Mr. Sivanagoda, with interest.
Pardon?
With interest.
Interest calculate ಮಾಡಿರಲಿಲ್ಲ.
ಕೊಡಿ ಸರ್ ಕೊಡ್ಲಿ ಆಯ್ತು
ಲೋಕ ಅದಾಲತ್ ಅಂತ ಹೇಳಿದ್ರೆ.
ಓಲ್ ಅವ್ರ
Yes, next.
Next list number 4.
It is in some other matter. This is today only I've done the calculation.
That is list number 4.
No.
That is list number 4, serial number 50. Serial number 50.
In list number?
4, serial number 50. You have arrived some calculations.
List number 3, serial number?
List number 4, serial number 50.
Oh, serial number?
50, 50.
Serial number 50, yes.
The enhancement will be 75,000 over and above.
There will be a court order. We will give the calculation. We request for the court order. We give the calculation.
Why not the joint memo?
Sir, why not means there is not the accident has taken place in 2017. The tribunal has taken not the income at 14,000 minutes, which is not correct. 11,000 we have reassessed. 11,000. The court has deducted one half. It should be 1/3. Then the loss of dependency will work out to 18,48,000 as against 18,27,000.
Which is the insurance company?
ICICI.
They are not here.
They are here.
They are here, but my client.
Then why not a joint memo?
Problem is
with his client.
My client insists for 14,500. It has been already.
No. Anyhow, this is
that is the
for
problem
taking
here.
out the bundle. It takes some time.
Yes.
She'll be taking out. In the meantime, I'll look at the other matter.
Yes.
Yes. Take out this 50 and then call the list and then do it.
Yes, please.
Number 4, serial number 1. 1. Father PM.
What about this?
I'm for respondent. We have given offer 1 lakh rupees, my lordship. But from the not yet confirmed matter, maybe tomorrow, my lordship.
Tomorrow. Same list.
Serial number 2.
Needful done, madam. Needful is done.
No.
Press of
What
state.
about
Owner liability, ma'am.
owner's?
Owner liability.
It is submitted. Needful is done. Is this matter after service of notice?
Serial number
3.
3. Memo for dispensation.
Memo is filed, second dispensation of notice to R1 dispense with. What about this?
Serial number 3, sir.
This is Syed Abdul Sabur. 3.
Does not come today. Maybe have it on any other day, my lord. I will discuss with him. His sister is not keeping well, therefore.
When?
Any
Day after?
day. Let us. I will
Day
try
after.
my level best.
Day after. List the matter, not day after tomorrow. Yes, 4.
Serial number 4.
File memo for dispensation of dispensation against R1.
Any scope for settlement? Liability on the insurance company? Let's see. What is? To give the file for.
ICICI.
Come to the table.
Page number 18.
What are the injuries?
Lower back.
Injuries, low back, right, my lord. Leg and other injuries over body. All over body.
Fracture. How many fractures?
Only one fracture, my lord.
So we'll grant 40,000 towards pain and suffering. Then loss of income during later period. Which year is the accident?
2014, my lord.
14.
2014. That is 8,500 into 3.
Doctor opined 16% physical disability.
1 minute. It comes to 25,500. Then how many days was in hospital?
10 days. 10 days.
Another 5,000 there. 10,000. Loss of amenities. What is the disability?
Disability doctor assessment.
Lower back dislocated. And doctor opined 16% disability, but trial court considered only 5% of disability. That has to be enhanced.
Let's come to the doctor's evidence.
Exhibit PW2.
No, here, where it is discussed.
At page number 18 only.
Page number 18. Please read.
Fourth line. He has also examined one doctor, Adarsh.
He is suffering from permanent disability. at 16% as per the records. The
16% to the limb, my lord, it is.
So 16% to the limb.
Particular limbo.
So court had taken rightly. So loss of, now coming to loss of amenities, court has granted how much?
That is.
5,000.
5,000, my lord.
That is lots of customers.
We'll take 15,000 or 20,000.
20,000.
20,000.
Then,
Pain and suffering, my lord.
then what about future loss of income? How much is which year you
Some
said?
is taken, but.
This is 2014.
14, date of accident 2014, 8,000.
8,500 into 12. What is the multiplier?
17.
17
Yes.
into 5.
23,000. He is an employee. Like the notional income. He is an employee.
Income evidence is there.
Yes.
How much is evidence? How much is income?
23,400 is this income.
23,000?
400.
Oh.
That was taken.
Taken?
Yes. 2,38,680 is granted. 2,39,000.
2,34,600 is coming to.
Granted.
Then
Pain
medical
and suffering,
expenses as it is.
Pain and suffering, it has to be.
That's increased 40,000.
Correct.
Future medical expense not considered by the trial court.
1 minute, 1 minute.
No evidence.
Loss of future income.
Future.
Implants removed. Implants removed. Implant removed. Consider ಮಾಡಿಲ್ಲ.
3% disability.
Future operation.
Not 3% disability.
So what is the operation? What are the future medical expenses?
What is the operation there?
For trial court they start. Sorry.
What are the
Before
future
trial
medical
court they
expenses?
start.
So it's coming to
In all other head malad, compensation is granted.
Next matter.
it comes to 5,02,000 so and so. Yes, Mr. Pradeep.
My lord.
5,02,000.
Please, ma'am.
They are there. It can be. It's from 3,90,000 to 5,02,000.
Yes.
Almost. Both the council submits, the land council appearing to the insurance company submits that they're ready to pay an amount of rupees 5,02,000 against the awarded compensation of an amount of rupees 3,90,000. Land council appearing to the petition submits that is agreeable to them, and both of them will file a joint memo before the Lok Adalat. List this matter on Thursday.
This memo for dispensation.
Memo is filed seeking dispensation of notice to respondent number 1. As a liability is fixed on the insurance company, memo is taken on record and notice to respondent number 1 is dispensed with. Next matter.
Cell number 5. Cell number 5. Raju, yes.
MSCT exoneration.
Yes, in this also
MSCT
memo is filed
exonerated
seeking
before MSCT, my lord.
dispensation of notice to R1 dispensed with at the risk of appellant. Yes.
Pain recovery order is there, my lord, in trial court.
Pain recovery order is passed.
They passed.
You are the?
For the claimant.
So you have no problem with that order?
I don't know. I have not issued any.
Huh?
In the file. He has to say.
Disability 90%.
Company has filed any appeal in this?
No, my lord. We are exonerated before MSCT, my lord.
No, is this pain and recovery is ordered?
Pain required, my lord, may be passed.
It's already ordered. They are seeking enhancement of the compensation. Give that, let me see.
My lord,
With the file.
MACT owner liability fixed, my lord, in MACT.
That's what he is also saying, Mr. Counsel.
He shall pay.
Hmm.
ಏನ್ recovery
ಏನ್
ಆದ್ರೆ?
recovery ಆಗಿದೆ?
ನೀವು argument ಮಾಡೋಣ.
Amritpal Singh was followed. Second respondent
recovery
insurance.
are
That's
been
what. So
already
it's only
passed,
on the
my lord,
quantum.
only
Not valid
enhancement
DLL
is it.
Please come to the order. Let's see the quantum.
Injuries are concerned.
4% is
4% disability is taken, blood.
No. How many are the injuries?
Only PW2 so says that not.
Fractures. How many fractures?
Fracture. Left ulna. Only one fracture.
ಇಲ್ಲ 2 ಇದೆ ನೋಡು
ಇನ್ನೊಂದು ತಗೊಂಡು ಓದಿ ಸರ್ ಹಂಗಾದ್ರೆ.
ಓದಿ ನೀವು ಓದಿ ನಮಗೆ
ಅಲ್ಲ ನನಗೆ ಗೊತ್ತಿರಂಗ ಎಲ್ಲ ಒಂದೇ ಫ್ರಾಕ್ಚರ್ ಕಾಣ್ತಿರೋದು ಅದಕ್ಕೆ.
Left fracture and left no 2 fractures I think.
Blood sustain left epidural fracture of chair.
Come towards pain and suffering.
As well ಅದೇ. That is the fracture ulna fracture.
ಇದೆ ನೋಡಪ್ಪ.
ಇವ್ರು ಇನ್ನೊಂದಲ್ಲ. ಸರ್ ಕಂಟಿನ್ಯೂಷನ್ ಓದಬೇಕು.
Epiphyseal fracture, what is that?
Blood ಹಲ್ಲಕ್ಕೆ ಕನೆಕ್ಟ್ ಬೋನ್ ಇರುತ್ತೆ ಅದು.
What is that? Because I don't know what it is. I'm asking you. Ulna fracture is the second one.
Please.
First is APIPHY.
Along with it is joined to that bone, my lord. That was fracture. Only one fracture that. It is not 2 fracture. According to what he said, that's the reason, my lord. Ulna fracture 4%. What the disability is taken is correct. Only thing is, my lord, now.
Are you reading at page number 19?
Page number 8, para 18 of the judgment I am reading.
Please read 21. 21.
20.
Please read what it is.
21. As mentioned here above, proved the established petition sustained left epiphyseal fracture and left ulna fracture. The very same bone, my lord. Connect with that. According to my knowledge.
No. So let's go with the layman's knowledge. It should be 2.
It may be, well, the doctor says.
It should be 60,000. Next.
Okay.
Next. Medical expenses. How many days he was in hospital?
3 days. Huh?
File is misplaced.
Now
File is misplaced.
ನಾನು ಏನು ಮಾಡಿಲ್ವಲ್ರಪ್ಪ. Disaster with medical bills 12,000, 15,000. It is not discussed in the judgment how many days he was in the hospital.
Anyhow, then we'll take that only. Medical expenses as it is, medical attendant, so and so. Then coming to the disability, which year is the accident?
This is 2014.
2013. Then it is 8,000.
14, 8,500.
Then into 12, what is the multiplier?
Multiplier, my lord, age about age is multiplier.
Age, what is his age?
1 minute, my lord. 18. 20%.
Look at the age. What is his age?
Age was
15 years. It shows
somewhere else.
Then what about this Master Mallikarjun?
The Master Mallikarjun is 1 lakh. For that time ready. But
how much is granted? 1,60,000. So there is no then what is the multiplier question will not come here.
No, what my respect submission in these type of cases via media we need to if we disagree.
So what happens is in this case then future law medical or that loss of income and all will not come. So if you have to apply Mallikarjun's case, it is 5%. Disability is 5%. Then there is a structured formula for that. Amounts and all.
Already reached 15 years at the time of accident.
15 years.
Notional income has to be taken. Coordinate bench has passed the order. You take the income of 15.
That is challenge in Supreme Court. That's why we are not considering that. Because Supreme Court judgment is saying something else. And the coordinate bench has taken a view. there are only two options. Either go with what they say or I'll adjourn this matter because when the matter is pending before the Supreme Court, I can't apply that. Adjourn. Memo for dispensation, I think, as filed seeking dispensation. You have already taken that? This one. Memo is filed seeking dispensation of notice to respondent number 1. The same is taken on record and memo is the notice to so and so is dispensed with. Admit post for final hearing, call for the PCR.
Till number 6.
Lord, I appear for the appellant, my lord. Lord, I filed memo for dispensation. They have agreed for 1,10,000. I sought for interest because, my lord, the tribunal is awarded only 3,000 for medical bills itself is 98,000, 97,000.
No
Lord,
doctor evidence.
2 grievous injuries. Unfortunately, claimant has not examined the doctor. 2 grievous injuries.
Yes, Mr. Shivanagoda.
Lord, 10 days he was in inpatient.
Earlier, I have discussed with him for 1 lakh.
I agree for 1,10,000.
He requested
I
to add interest also. I said that is not possible. There is no medical evidence. So it's very difficult for me to give a calculation. Therefore, in spite of that, my lord, I have offered 1,10,000 in addition to what now he is asking for interest. That is not permissible. If he is not ready, my lord, let the matter be heard.
97,000
So for hearing this matter, it takes some more years, 21.
Lord, I'm not
If you want, let the matter may be remanded to let him examine the doctor. Let him take.
I sought for 6% interest, 1,10,000.
No, that is not.
Could be, my lord. I request this honorable court. It may be 1,25,000. I will deposit.
So without interest, 1,25,000.
It will not come even calculation of interest also.
You said 1,15,000.
I said, my lord, 1,10,000. Another 5,000 because of this is a lesson for us also.
Submit that the land council appearing for the insurance company submits that they are ready to pay an amount of rupees the global compensation of 1,15,000 in addition to what has been awarded by the tribunal, and both the parties will file the joint memo. This is matter before the Lok Adalat. Next.
10-7.
Memo for dispensation. Same is dispensed with how many days? So and so. IN number so and so is filed to condone the delay of so and so. For the reasons stated in the accompanying affidavit, the delay is condoned, and on the condition that the petitioner appellant will not be entitled for the interest for the in case of enhancement. Yes, next.
Till number 7.
Appear for the
Please.
appellant, my lord. A place of week's time, my lord. The notice has to be go for the
No, shall we do the calculation? Any scope for?
Yes, my lord.
We can. Court has taken the disability was assessed by the doctor 16%.
16%, my lord. The
16% to the whole body.
Please,
Yes.
please.
Court had taken
16%. The
15.66% was assessed.
And it
16
takes,
was
Court has
taken.
taken 16%.
On what ground you are before the court?
my lord, the notion income is taken as 9,000. The date of
Correct.
accident is
It should have been
2018.
Correct. 2018.
2008.
2018. It should be 12,500.
Please.
12,500.
That's the only ground.
And also, my lord, for the laid off
Table.
given that as 9,000.
Para 35 make.
Come to the
Para 35.
table.
My lord, page
Table,
25
table,
in
table.
page 35.
It's a case of death. It's a case of death.
No, my
Please.
lord, injury.
The injury case.
There are two MVCs here. Page number you said?
The connected in the 410, my lord, 2019. The
410.
second connected one.
Para 35
One
of the
minute.
judgment.
1 minute. So, as far as the medical expenses are concerned, no dispute.
Please. That income is concerned, there is no dispute.
1 minute.
The
1 minute.
expenses, they only give a 5,300,
1 minute.
5,374, my lord.
So, medical expenses 5,374. Pain and
In the
suffering.
future, also it cost 80,000, my lord, to me.
What?
Like the medical expenses after the accident.
No.
For the future treatment also I got the expenses that is not awarded.
There is no evidence for that, ma.
So let's look at the other heads. How many are the injuries? How many fractures?
My lord,
one left leg, my lord, fracture.
Only one fracture?
One fracture and grievous injury like right hand, left finger and forehead.
So another 10,000 will grant under pain and suffering. How many days was in hospital?
2 months.
Huh?
2 months.
2 months.
Correct?
Hospitalization.
Hospitalization is 3 months, my lord.
3 judgment. 3 months ಅಲ್ಲ ಇಲ್ಲಿ.
Where do you get that?
In para 33.
31 ಮೇಲೆ para 31. No my no ಅದಲ್ಲ ಇಲ್ಲಿ ಹೇಳ್ಬೇಕಾದ್ರೆ ಇದು.
The next aspect is a discharge summary produced by
11 to 29 malad 18 days.
18 days court has already granted 35,000. No enhancement there. Then loss of income during laid up period. Yes, this we will increase.
3 months was granted.
No, which year is this accident? 2000?
2018 not 12,000.
2018.
So 12,500 into 3. It comes to 37,500. Then loss of future income. 12,500 into 12. What is the multiplier? Multiplier.
35 years. 16 multiplier.
16 and the disability is 5%.
16%.
16% is the
16%. It comes to 3,84,000. Then future medical expenses.
Multiplied 11. 55 years.
55
Oh, he
years.
said 16. No.
Para 33.
6% of disability.
11. 1 minute. 12,500 into 12 into 11 into 16,100. It comes to 2,64,000. Then future medical expenses, court had already granted 20,000. Where is loss of amenities?
Amenities granted.
Loss of amenities not granted. Loss of how much?
30,000.
I thought 20,000. That's why I asked you.
No, but 16% is
That's
very
why-
femur
that's why.
fracture is there. So
5,374 plus 35,000 plus 37,000. 64.
money.
It's coming to 4,51,874 against the granted compensation of 3,27,454. Yes.
Correct.
Hmm?
For that one,
Both the part, it is submitted with the accounts for the insurance company that insurance company is ready to pay an amount of rupees 4,51,874 against the awarded compensation of 3,27,454 at 6% interest.
delay.
And it is submitted, both of them will file the joint memo before the Lok Adalat on Thursday. List this matter on Thursday. Yes, next.
Appear on behalf of R1, my lord. Negotiated, my lord. It comes to around 4,45,000, my lord.
Where
Case
are
of
they?
death.
What was the amount granted? So now, against
Addition-
in
global.
addition to in addition, global.
In addition, global.
It is submitted that in addition to the compensation that is granted 15,82,000, the insurance company is ready to pay global compensation of
45,000.
4,45,000, and both the parties will file a joint memo before the Lok Adalat. List this matter before the Lok Adalat. Next matter.
Your Lordship, I am for the appellant.
First, in 8, Memo is filed seeking dispensation of notice to R2, same order, dispensed with. Then 9,
Your Lordship, I'm for the appellant. There is negligent, Your Lordship. 2 days time may be granted.
this is matter on Thursday,
Please, Your Lordship.
list it on Thursday. Yes, next.
Bill number 810, Sridhara DS.
Yes, of that.
What about this?
Yes, of that, my lord.
Where is Sridhar S, DS? No representation. Huh?
He's not keeping well.
He's not keeping well.
Sham Prasad name may be shown, my lord. So he will come.
Shall I ask him to print the name?
I will ask him to.
Inform him, tomorrow we'll take up.
Please. Sham Prasad.
Yes, 11.
Bill number 11. Bill number 11.
What about 11?
11, ready, my lord.
This also
Fracture.
tomorrow. No representation tomorrow. Next 12.
Memo for dispensation to notice to R2, my lord. Case of death.
We can do.
We can
40,000 income, my lord, and
Already discussed.
Please, we have discussed, my lordship, but the judicial
judicial order, my lord.
What is, have you done the calculation?
14,000 into 40%, my lord.
1 minute, come to the table.
Page number 17 of the judgment, my lord. 11,000 is taken, 2019 action.
11,000 is correct.
19 action, 14,000.
14,000, my lord.
So
Instead
just
of
wait.
11,000,
1 minute,
14,000.
14,000. What is the age?
33 years, my lord.
So 40%
40%,
future
my lord.
prospects.
5,600. Madam.
5,600. It comes to 19,600. And how many are the dependents?
One third, two
One
persons,
third.
daughters, one third, deducted already.
19,600. It comes to 6,533. The salary now comes to 13,067
Yes, ma'am. Into 12 into 16, ma'am.
into 12 into 15.
16, ma'am. 25 lakhs, 8,000.
23 lakhs.
25 lakhs, 8,864, ma'am.
No, let me look at it again. 13067 into 12 into 15.
16, ma'am. Multiple.
Multiplier 16, my lord.
It's coming to 2,50,000. 25
lakh, 8,864.
8,864.
Yes, minus 19 lakh, 71,000, ma'am.
No. What about the other heads, sir?
Other heads,
How many are
80,000.
the? How many are the claimants?
2 persons, my lord.
Two.
80,000 is given and 15,000 is given.
80,000. It has to be, if it is a judicial order.
Yes, madam.
88,000.
Yes, madam.
88,000, 36,000.
Yes, madam. Medical bills already awarded 87,000.
How much?
87,000 already awarded.
87,000.
7,000.
Round figure.
Yes, madam.
So, plus 88,000 plus 36,000 plus it's coming to 27 lakhs 19,864 against 19 lakhs
Against, my lord,
71,000.
total 21 lakh 68,000.
Where do you get that? You're saying the table is at page 17.
Page 18, my lord. 80.
So against 21 lakh 68,000, it comes to 27 lakh 19,864. So now the issue, how much was the income taken by the court?
11,000, my lord.
Future prospects were not granted.
Added, my lord.
Added, my lord.
But taken at 11,000.
Yes, ma'am.
That's the only calculation. Please come. What is this MVC number?
MVC number 499 appointed.
Agreed with the
499
order passed. Only one MVC.
Only one MVC.
No, there are two. What are these two calculations?
My lord, this is bifurcation 30 in page number 19 bifurcation, my lord, for petitioners. The court has bifurcated the amount, my lord. Page number 18 is the calculation, 19 is the bifurcation to the petitioner's amount.
Agreed with the award passed in MVC number 499 of 2020, dated 3rd February 2021, whereby the court had granted 21,68,000 as a compensation. The claimant is before this court. Land counsel appearing for the claimant submits that the court, the accident had taken place in the year 2019. Court had taken the income, notional income at 11,000, which is on the lower side. As such, the claimant is before this court. Land counsel appearing for the respondent also does not dispute the fact that for the notional income for the year 2019 is 14,000. If in the same fashion, if it is calculated, the loss of dependency 14,000 plus 40% future prospects will come to 5,600. That is 19,600. 1/3 has to be deducted towards personal expenses. That is 6,000. That is 6,533. Then the contribution to the family is 13,067 into 12 into 16 is 25. Loss of dependency, it comes to 25 lakhs 8,064 towards consortium 88,000, funeral expenses 36,000, and medical expenses granted or 87,000. It comes to 27 lakhs 19,864. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 21 lakhs 68,000 to 27 lakhs 19,864.
It's 6%.
Interest is 6%.
Please, madam.
Memo is filed seeking dispensation of
Notice to R2, my lord.
dispensation of notice to R2, same dispense with at the risk of appellant. Yes, next.
Cell number 13. Cell number 13, month of 5.
Yes, who takes notice in this? 13, you take? Mr. Shivanagowda is directed to take notice on behalf of the respondent insurance company. In the name of Mr. Shivanagowda, list this matter tomorrow. Yes, 14.
Cell number 14.
What about this?
Can be settled.
Tomorrow. Please inform the councils also.
Please, I will.
15.
Cell number 15.
15 may be adjourned, my lord.
It has to be adjourned.
Please, madam.
The petitioner, the appellant shall do the needful within a week default, or otherwise the appeal shall stand dismissed. Yes, post after service of notice. Next,
Cell
16.
number 16.
What about 16?
It can be settled.
Can be settled. List this matter tomorrow.
Cell number 17.
It is 17. Memo is filed seeking dispensation of notice to R2. Dispense with at the risk of appellant. Yes.
A week's stay may be granted to take steps, my lord.
What steps?
Respondent number 1 is the one of the claimant, my lord.
For taking steps to R1, a week's time is granted. Default.
Cell number 18. 18.
Memo is filed seeking dispensation of notice to R1 dispensed with. Yes, Mr. Shivanagowda. Mr. Shivanagowda takes notice on behalf of the respondent insurance company, R2 insurance company, print his name. This is matter tomorrow. Yes, 19.
Cell number 19.
Memo is filed seeking dispensation of notice to R1, same dispense. Admit post for final hearing. Call for the TCR.
Cell number 20. 20.
For taking steps, 2 weeks time is granted. Default order. 21.
Cell number 21.
For the appellant, your lordship.
Ready? Yes. Memo is filed seeking dispensation of notice to R2 dispensed with. Give the file. It's a case of
Death, your lordship.
Come to that table. Which year is the accident?
Your lordship, the accident is the year of 2019, your lordship.
Then it should be 14,000.
Please.
Age?
Age 24 years, your lordship. Dependents are his mother and father, Your Lordship.
Yes.
He was working as a driver.
1 minute, 1 minute.
1,62,000.
50% has to be deducted.
Please, Your Lordship. It's been deducted. This one. 1817.
So his salary is 9,800
Please, Your Lordship.
into 12 into 18 or 16. What is the multiplier?
12, Your Lordship. 12.
18.
Sorry, Your Lordship. 18.
It comes to 21 lakhs 16,800. Then how many are the claim is for the father and mother?
Father and mother.
So 44 plus 44, 88,000, then 36,000. It comes to 22 lakhs 40,800 against 19 lakhs 24,400. Yes, Mr. Shivanagoda. What about this? You are not appearing.
Anup Sitaraman.
Where is Mr. Anup Sitaraman? Let's have this matter tomorrow. Tomorrow for judgment. In the same list.
Dispense. Serial number 22. Nagaraj Reddy.
That is settlement.
22 is 3765.
We have already settled the matter. I have given the list.
Where is the list? Oh. 22.
All these are inclusive of interest.
Oh. They have agreed. These are all inclusive of interest. It's like a global compensation of
yes.
MFA 22. I mean, in item number 22, it is submitted that the respondents are ready to pay an amount of rupees 2 lakhs.
2 lakhs, sir.
2 lakhs globally, and parties will file a joint memo before the Lok Adalat on Thursday. Then we will record first all this. Then 30. 30.
That we can do it, Malad. Sripas has more matter than death case. There are death cases. So we can.
We'll do. 30. 1,80,000. Same, like globally. Then 32.
Delay has to be condoned.
In 30, there is a delay of 117 days. Condone, no condition. Next 32. 32.
3,60,000.
3,60,000 globally.
Please.
Then same, all of this joint memo on Thursday.
Please.
Any.
Then 43. One minute, 41 also settled. 41 is?
1 lakh, my lord.
41,
Global.
1 lakh globally.
And 43, my lord.
43,
1 lakh 25,000.
43, 1 lakh?
25,000.
1 lakh 25,000.
And 52, my lord.
Globally. Yes. This is there in the list. I am looking at it. Then 52. 52, 10,000
Please,
globally. Then 59.
Number 93.
59, 1,55,000 globally. Then 63 is 3,40,000. Then 64, 1,30,000. Then 81. 4,80,000, 86, 7,20,000, and 89, 1,70,000, then 90, 1,60,000, 93, 1,50,000. Yes.
Serial number party 1 ನಲ್ಲಿ
No, we will call because he said I'm recording it. I'll call the number. I'll call the number. Settled.
41, my lord. What happened here is, my lord,
1 minute.
this is a case of death, my lord. Initially, case was filed by wife, by mother and sister.
Mother and daughter.
Mother and sister, and they made daughter as the third respondent. After the judgment is passed, my lord, mother passed away. The tribunal has not awarded any compensation so far as the sister is concerned because they have not proved that she was dependent. Now, the petitioner appellant herein is only the respondent number 3, who is the daughter, my lord. So the entire amount may be released in favor of the appellant.
How can it be done without there should be a judicial order for that? Can't do it.
Maybe globally it may be recorded and it may be
41 tomorrow. 41 tomorrow will
Please.
pass judicial order.
Please,
This
madam.
for judgment. 41 tomorrow for judgment.
Please, much.
Yes. So coming back to the list.
One submission, madam. Serial number 64, madam.
Serial number?
64.
1 minute.
64.
64 it's already
No,
recorded.
madam. We have agreed for 1,30,000 rupees, madam. Claimant demanding 1,50,000 rupees, madam.
My lords, the trial court has erroneously granted only 7% for the disability, my lords. 20% disability, the government
So
hospital
this has to be heard.
My lords.
64 delete it. No, that whatever you have recorded, we'll hear it.
Tomorrow, madam. Please, madam.
It will come. Whatever that's not heard today, it will come tomorrow. The
Please,
list.
madam.
So where are we? Yes, Ms. Sivanagoda, you are saying something about?
Serial number.
What about 23?
Sir, for appellant, my lordship.
Hmm.
MSCT order pay and recovery, my lordship.
Hmm.
By mistake, filed the memo, dispensation memo, and also owner appeal filed. My lordship.
One also filed appeal.
Yes. MFS 6433 bar 2.
So 23,
Dispensation memo not.
the memo that is filed seeking dispensation of the notice submits that he wants to withdraw. You want to withdraw that.
Please.
Withdraw
Not
as
pressed.
as not pressed as a pay and recover order is passed by the court. So take out pay the process.
Also MFS 6433 bar 20.
Pay the petitioner shall take, the appellant shall take steps as issuance of notice to R1. List this matter along with, give that number to, along with so and so.
Please.
Next 24.
Serial number 24.
This memo for dispensation of notice to R1 dispensed with, admit post of final hearing TCR. Next 25.
Serial number 25.
Yes, Prakash.
I am for
MH.
respondent, madam.
Where is she? She was here.
Tomorrow, madam.
Tomorrow. 26.
Number 26.
Same memo is filed seeking dispensation of notice to R1 dispensed with. List this matter tomorrow. Yes, 27.
27.
I think that matters are there, madam. So,
ಬಂದಿದೆ ಅದು.
6049 and 6067 of 22.
They can be settled or it has to go for hearing.
I think two insurance companies involved. One is Cholamandalam and another one ICICI. They have to.
You appear for Cholamandalam.
Please, madam.
Calculation.
Both of them.
Then give those numbers, post this this appeal along with so and so, so and so.
Tomorrow.
Tomorrow. Yes, 28.
Serial number 28.
27 also, wherever in the list, there is a memo for dispensation, that will please order. Yes, 28.
Serial number 28.
This also tomorrow. Memo is filed seeking dispensation of notice to R to same dispense with. Then 29.
Number 29.
I am for respondent number 1, madam.
Go for settlement.
Please, madam. Tomorrow.
Tomorrow. This is matter tomorrow, 29.
30.
30. It's already,
Already.
yes, 31.
Latur Suresh.
This also, to the petition, the appellant shall do the needful within a week default order. Next, 33.
Serial number 33.
Yes, Sripad Vishastri.
My lord, I am for appellant, my lord. My lord, two vehicles, two insurance companies, both are held liable. So R2 and R4 presence is necessary, and R1 and R3, my lord, I have to file the dispensation memo, my lord. It may be dispensed with, I will file the memo, my lord, in the registry.
Yes.
All death case, all are death cases.
So when will you argue?
Today itself, my lord, there is a
Memo you will give later.
yes, my lord. As far as 7875 is concerned,
take that.
my lord, a coolie accident is of the year 2018. Instead of taking 12,500, 9,000 is considered.
No, what we do is, Mr. Shastri will go by number wise. First, MLA number 7875.
Yes. It arose from 5643/18. My lord, wife, 4 minor children and mother, total 6 are the claimants. My lord, accident is of the year 2018.
No.
My lord, is a coolie age 30 years.
Is arising out of MVC?
5643/18.
5643/18.
Where
is the table concerning this?
My lord, it is found in, sorry, my lord. Actually, it is a transferred brief, that is why.
Where is the table?
In that case, my lord, I don't have any table. In other 3 cases, I had a table because it is appeared by Jagadish.
Five, 6, 4, 2. Sorry, my lord, extremely sorry.
Madam, I don't thought in next case.
MVC 5643. Yes. Come to para 55. It starts from there. And the table is at para 64.
Yes.
So
64,
which is that?
yes. My lord, monthly income 9,000 is considered instead of 12,500.
This is 2020.
To follow online appearance. 12,500. What is the age?
30 years, my lord.
20, my lord. Date of accident.
Year of accident 20.
He's saying 2018.
Yes, 2018.
This is 2018, correct.
2018, my lord. Because MVC itself.
Age of the deceased.
30 years, my lord.
30 years.
Coolie. My lord, wife, 4 minor children, and the mother. Total 6 persons are the dependents. 6 dependents. My lord, 12,500 is required to be considered, and 40% is to be added. That comes to 17,500. My lord, 1/4 correctly deducted. So, deducting 4,375, it comes to 13,000.
1 minute. Ms. Shastri, I'll do it. Please wait. What is the multiplier?
30 years, my lord, 17. My lord.
17, sorry.
It comes to 26 lakhs, 77,500. Then 44 into 6 comes to 2,64,000, 36,000. It comes to 29 lakhs 77,500 against the compensation of 19 lakhs 51,148. Judicial order or a memo?
I am ready for everything.
There is nothing.
But
Because it is not, we have not, it is as per the table.
Yes, yes.
So it has to be, file a joint memo.
Company or joint memo. Chola.
Judicial order may be passed.
No, whatever it is, no, it is as per the law. Nothing, court is not giving any extra amount.
Where company, my lord?
What is your company?
Cholamandalam.
Oh.
There are two
So
companies.
both jointly, severally, joint and severally liable.
Plus 50%.
Agreed with the order passed in MBC number 5643 of 2018, dated 21st June 2022. The claimants are before this court seeking enhancement of the compensation. As on the date of the accident, the age of the claimant is 30 years, and he was working as a
Coolie,
he was working as a
coolie, madam. Coolie.
Court had and the claimants are 6 in number. The court had taken 9,000 as a salary and taking 25% future prospects had granted an amount of 19,51,148 and held that both insurance companies are jointly and severally liable to pay the compensation. Land counsel appearing for the claimant submits that the accident had taken place in the year 2019. The court ought to have taken 12,500 and future prospects should have been at 40,000. And it is submitted that under the other heads also, the compensation that is awarded by the tribunal is not a just and reasonable compensation. Land counsel appearing for the respondent insurance companies, both the companies submit that the court had reasonably granted the compensation and there are no grounds to interfere. Next para. Having heard the counsels on either side, peruse the material on record. This accident has happened in the year 2018 and as per the table prepared by the Legal Services Authority, the salary has to be taken 12,500. The future prospects at 40% comes to 5,000. Then the salary is 17,500. As there are six dependents, 1/4 has to be deducted, and the 1/4 is 4,375. Then the contribution to the family would be 13,125 into 12 into 16.
Multiply
17, madam. Triple as adopted.
26,77,500 towards a consortium of 6 people, 6 into 44, 2,64,000 towards funeral expenses, 36,000. Altogether, the claimant is entitled for an amount of rupees 29,77,500. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 19,51,148 to 29,77,500. And both the insurance companies are jointly and severally liable to pay the compensation. Yes. What about the next one?
Same, my lord. The
age is 54 years.
How much delay?
Blood,
IA number. Where do you get that? 33. IA number 2 of is filed to condemn the delay of 40 days for the reasons stated in the accompanying affidavit. It is condemned. Next, 34 is arising out of.
It is 5642.
5642.
Give the next file.
5642. Table is in this page number 35.
Pardon?
MVC number?
5642 of 18.
Page number
Which
35.
paragraph?
Page number 35 is the.
1 minute.
Page 31, para 67.
So what is this? What is the age in this?
52 years, madam.
So 12,500. Future
10%.
prospects 25%.
10%.
10%. 10% is then
1,250.
1,250.
250.
He's aged 40 years, my lord. 40 years. Finding is found in.
No, please.
Para 73 may kindly be seen, my lord.
Para?
73. As per exhibit P4, 24.
Birth year of the deceased is 1978.
Yes.
Yes, 40 years.
40 years.
That is next case.
So 40
Next
years
case
old.
will come.
Future prospects like in the other case
Yes.
would be 40%.
That is not the case.
Hmm.
Now your lordship is 7876 MFA, your lordship is adjudicating.
1 minute.
5642.
I am looking at MFA number 7876
Please.
of 2022
In
arising
this
out of
aged about 52 years, 10%.
arising out of MVC number.
5642.
1 minute, let me look at this from the cost side. It is arising out of MBC 5642.
Please.
5642 is at paragraph number 64, I think.
Correct.
No, 564. This is
Alla,
5642. 5642
Column,
is 1 minute. 5642 starts at para 43.
43.
Yes. In that, what is the age?
correct.
52 years old.
52 years, my lord.
Yes. Para 51, my lord. Correct.
Correct.
13,750. How many are the?
One fourth, my lord.
1/4. 1,750 into 1 divided by 4. It comes to 3,437.
Just to 11 multiplied.
It comes to 10,313 into 12. What is the multiplier?
11. 11.
Huh?
11.
Yes, Mr. Shastri, do you
Yes,
again?
yes. 11, my lord. 11.
It comes to 13,61,316. How many are the claimants?
Six in number.
Not in the earlier matter, there are 6. In this matter,
In this also. 5643 low. 6.
it comes to 2,64,000. 36,000.
Co-dependent.
It's 2,64,000 plus 36,000. It comes to 16,61,316 against the
10,100.
awarded compensation of 12,10,100. Yes, agreed with orders passed in MVC number 5642 of 2018, dated 21st June 2022. The claimant is before this court seeking enhancement of the compensation. Then counsel appearing for the claimant submits that the court had taken the notional income at 9,000, which is on the lower side. And as this accident has happened in the year 2018, court ought to have taken 12,500. And even under the other conventional heads also, the amount that is awarded by the tribunal is not a just and reasonable compensation. Next parallel, counsel appearing with the respondent insurance company submits that the court has considered all the aspects and rightly granted compensation and no enhancement. There are no grounds for enhancing the compensation. Next para, having heard the counsels on either side, there is a material on record. The accident has happened in the year 2018. The court ought to have taken 12,500 as the notional income. The age of the deceased is 53%. 10% future prospects. 53%. The future prospects comes to 10% is 1,250, and the salary is 13,750. The dependents of 6 in number, if 1/3 is deducted, 1/3 comes to 3,437. 1/4 comes to 3,437. Then his contribution to the family is 10,313 into 12, and the multiplier 11. The loss of dependency would come to 13,61,316, and the consortium 2,64,000, and the funeral expenses 36,000. Altogether, the claimant is entitled for an amount of 16,61,316. Accordingly, the appeal of the claimant is partly allowed enhancing the compensation from 12 lakh 10,000 to 16 lakh 61,316. Give the next file.
My lord, it is 5644 of 18, page number 31, para number 67.
Mr. P. Pradeep takes notice on behalf of the
40 years.
respondent insurance company. Yes.
My lord, wife, 2 minor children and father,
One
total
minute,
4.
let me take the file first.
Page number 31, my lord.
Paragraph number?
Page number 31, para number 67, 5644. My lord, 40 years old, 1978 born.
1 minute, 1 minute. Paragraph?
67, 5644.
So
9,000.
it has to be
25%.
Same 12.
25%, 12,500.
40 years. 40 years.
Completed, man. 25% is taken.
Taken 15 is adopted. It is all intact. 1/4 is deducted. Only 12,500. It is only required to be considered.
How many are the dependents?
4.
4 dependents.
1/3.
1/4 is
1/4.
Oh, 1/4.
4 dependents.
Up to 4, 1/3.
1 to
please.
Huh?
Yes, no. 1 to 3. 1 to 3 is 1/3. 1 to 4 up to 6 1/4.
2 to 3 1/3. 4 to 6 1/4. It comes to 11,719 into 12 into what is the multiplier?
15.
21 lakhs 9,000.
21 lakhs 09420. Then 4 into 44. It comes to 1 lakh 76,000. 36,000.
Tribunal has taken, Malad.
Huh?
Tribunal has taken 44. 4,000 add madilla.
Comes to 23 lakhs 21,420 against
17 lakh 8,660.
17 lakhs?
8,660.
Page number?
Page number 31, para number 67 onwards.
Yes, I found that. 17 lakhs 8,660. Please come. Agreed with award passed in MEC number 5644, dated the same date like in the earlier, dated so and so, whereby the court had granted compensation of 17 lakh 8,660. The claimant is before this court seeking enhancement of the compensation. Then counsel appearing for the claimant submits that the court had failed to take the income at 12,500 as this accident has taken place in the year 2018 and granted the compensation and had failed to grant a reasonable compensation. Even under the other conventional heads also, the amount that is awarded by the tribunal is not a just and reasonable compensation. Next para. Then counsel appearing for the respondent insurance company submits that the court has considered all these aspects and granted a just and reasonable compensation. Next para. Having heard the counsels on either side, Caruso Mitchell on record. This accident has taken place in the year 2018 and the notional income has to be taken at 12,500. Considering the age of 40, future prospects at 25% comes to 3,125. The salary is 15,625. As there are 4 claimants, 1/4 has to be deducted towards the contribution, that is 3906. Then towards 3906 has to be deducted towards his personal expenses, and the contribution to the family would be 11,719 into 12 into 15, 21 lakhs 09420 is a loss of dependency, and for 4 people towards consortium, 4 into 44, 1,76,000, and towards funeral expenses 36,000. Altogether, the claimant is entitled for an amount of rupees 23 lakhs 21,420. Accordingly, the appeal is partly allowed, enhancing the compensation from 17 lakhs 8,660 to 23 lakhs 21,420. For R4, Mr. B. Pradeep takes notice.
And R1 and R3.
Notice to R3 and notice to R3. That you have to file tomorrow, please give that.
Tomorrow it's.
The 33 and 34, in 33 and 34, Land Council submits that. That is the docket order. 33 and 34, Land Council submits that.
35 also.
33, 34 and 35. Notice to who
One,
it is not
notice to 1 and 3.
1 and 3 is not necessary, and he will file a petition seeking dispensation of notice to them. Next, in 35, notice to R3 returned as refused, amounts to deemed service of notice. Yes, and held sufficient. Condone. Yes, in all the matters delay is there. Look at it, in all the matters the delay is there, less than 150 condone, or else with condition. Yes.
36.
I think remaining matters will take up tomorrow. What about your matter?
Serial number 39, my lord. We have agreed for 90,000 rupees.
What about them?
Serial number
39?
Please, my lord.
39 globally?
Globally 90,000.
39, both the parties, it is submitted that it is agreed that the insurance company will pay what is that?
90,000 rupees, my lord.
90,000 rupees globally, and they'll file a joint memo. List this matter before the Lok Adalat on Thursday.
Serial number 49, my lord. List along with MFA 8127/20.
49?
49.
List along with?
8127/23.
Now or it can be settled or later time?
Later. Claimant.
That the petition in 49 MFA, the appellant shall do the needful within a week default order, then list along with so and so.
8127/20.
Give it to the court officer.
It's sufficient, madam. Serial number 45, madam. It is a case of death of 13-year-old boy, madam. Tribunal awarded only 5 lakhs. I am reading upon Kajal and Marshal Ayush case, madam. That is minimum wages has to be taken into consideration.
What has happened? What is it's a case of
13-year-old death, madam. Case of death.
Minor death.
I think in some of the cases I have passed order and he said that it is carried to the Supreme Court. What happened to that?
It is pending, madam. Stays are pending consideration.
Then we'll adjourn this matter.
Please, madam.
45, memo is filed seeking dispensation of notice to R1, dispensed with at the risk of appellant. List this matter. No, the notice is completed.
Please,
Admit post for final hearing. Call for the DCR.
Serial number 44.
40?
Memo for dispensation for R1.
Take that. Memo is filed seeking dispensation of notice to R1 as a liability is fixed on the insurance company. Same memo is taken on record and notice to R1 is dispensed with at the risk of appellant. Admit delay is there. IA number 1 of 23 is filed to condone the delay of 137 days. Same for the reasons stated in the accompanying affidavit. The delay is condoned. Admit post for final hearing. Call for the
One submission. It is only one point. Considering the income is concerned. The tribunal was.
It can be taken up tomorrow. 44 tomorrow.
Yes.
What all the remaining matters will come in the list. Who do not want the matters to be tomorrow, they only mention it. Otherwise, don't have to mention. All the matters will come tomorrow.
That is serial number 50. So only a small announcement, my lord.
Yes. All other matters will come in the list. Other than that, any mention?
My lord, serial number 47 and 67, my lord. Kindly may I have it on Thursday, my lord.
47 and
Why?
Tomorrow slight inconvenience, my lord.
You
That is
can
the
appear
reason.
online. We will decide matters tomorrow. They are coming. Insurance companies are here. That's why.
Yes, please, my lord.
Yes.
No trouble.
My lord, accident is of the year 2017.
The case of death or injury.
Case of death.
Hmm. Where is the
Defendants are-
table? Come to the table.
Please, my lord. Page number 17.
Page number?
17. Para 17, page number 14.
Yes, I have seen this.
My lord, it is wrongly concluded as 2020 accident. It is of the year 2017.
2017. What is the income on 2017?
11,000.
11,000.
1/3 deduction.
And what is the age?
Age is 38 years.
38 years.
So 40% future prospects.
Yes, madam.
40% future prospectus.
So 15,400. How many are the dependents?
Two dependents, wife and minor children.
So how much? 1/3 has to be deducted?
1/3.
1/3, yes, madam.
And that it will be 18,48,000.
1 minute. Comes to 5133. It comes to 10,267 into 12 into what is the multiplier?
Multiplier is
15.
15.
It comes to 18 lakhs 48,000.
Yes, madam.
060. So two claimants, 88,000, 36,000. Plus.
That's I have given 20% escalation, madam. That will be madam, little more.
My lord, under loss of estate, 18,000 we have calculated.
So 1 lakh, it comes to 19 lakhs 72,060.
My lord, under the loss of estate
Yes.
and funeral expenses.
I have granted 88,000 plus 36,000. It would be more than what is granted.
Yes, please, ma'am.
It is coming to 19 lakhs 72,000. It is an insurance company. You are
That's
representing.
ICICI.
Two insurance
ICICI.
Sir, here, you can
ICICI.
file a joint memo.
No, it can't be my. Two insurance companies.
Oh, contributory negligence.
Yes.
Two insurance companies
Yes.
are there. ICICI and
And madam,
India.
United India,
where is United India? Who is representing?
Mr. A. Venkatesh.
It can be.
Tomorrow we'll say for judgment.
Let there be a judicial order. Let there be a judicial order.
That's why tomorrow
Yes, ma'am.
heard land counsel appearing for the petitioner and the counsel appearing for the ICICI
Yes.
Lombard. No representation for the, which is that insurance company?
United India Insurance.
United Insurance Company. List this matter for judgment tomorrow.
Please.
Where is that? Memo is filed seeking dispensation of notice to
Delay of
2 and
256.
R3.
Delay.
Dispensed with at the risk of appellant. Then I have 1/24 risk to condone the delay of 256 days. Condoned on the condition.
Serial number 57, we have settled for global sum of rupees 2,40,000.
Settled?
Settled.
50?
57.
Global sum of?
2,40,000. There are two
40,000.
insurance company minutes, 50-50 each.
It is settled.
Yes, yes, it is settled.
It is submitted that the insurance companies are ready to pay an amount of rupees 2,40,000 globally. And the insurance companies, the parties will file their joint memo before the Lok Adalat. List this matter on Thursday before the Lok Adalat. Yes. IA number 1/22 is filed to condone the delay of 51 days in filing. Condoned. Any signatures? All the matters shall come tomorrow.
ಹೋಗಿ ಹೋಗಿ.
ಫೈಲ್ ಅಲ್ಲೇ ಇದೆ.
ಇದೇನ್ ಮೇಡಮ್? ಇದು ಅದೇ ಇವಾಗ ಆಗಿತ್ತು ಆರ್ಡ್ರು ಪಿನ್ ಮಾಡ್ಬಿಟ್ಟು ನಾಳೆಗೆ ಫಾರ್ ಜಡ್ಜ್ಮೆಂಟ್. ಫಾರ್ ಜಡ್ಜ್ಮೆಂಟ್ ಟುಮಾರೋ. ಇವ್ರೆ ಇದು ನಾಳೆ ಫೈಲ್ ಎಲ್ಲ ನೋಡ್ಕೊಂಡು ಹೋಗ್ಬೇಕಲ್ಲ.
ಇನ್ಸರ್ಷನ್ ಬೇಕಲ್ಲ ಅದಕ್ಕೆ ಇವಾಗಲೇ ಕಳಿಸ್ತೀನಿ ನಾನು.
ಅವ್ರಿಗೆ ಆ ಫೈಲ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲ ಫೈಲ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲೆಲ್ಲಿ ಡಿಲೇ ಅಲ್ಲ ಅವರು ಡಿಲೇ ನೋಟಿಫೈ ಮಾಡ್ಬೇಕಲ್ವಾ ಇವ್ರೆ? ಅಲ್ಲ ಎಲ್ಲಾದ್ರೂ